wasn't even thinking about me being on the show. I wanted to produce something for them.
Cool celebrity. Like if I went to the mall and stuff, people like, oh,
The thing was, I didn't even know that anybody ever thought I was ugly.
We look like twins almost.
Okay.
She really wouldn't be able
Covering any more subjects related. So that's why you got the raw reaction. This is pathetic. It's pathetic. Hit that like button. Hit that like button. You better stop fronting. Hit that like button. Let's go, let's go. Hey. Come on in, y'all. Have a seat, because we're gonna be here for a while. There are some updates. So we're gonna be here for a minute. So get your drink, get your smoke, whatever you do, get your shit so you can sit back and sip this tea. Let's go. Let's go. Let's go. Let's go. Let's go. Hey. Hey, Monica. Hey, Lynn. Hey, Hubbard. Vanderveer. And Alice. And Monica. And Queen of Harlem. We got Debbie. And Alice. And Chelsea. And Mimi. And Netta. Hey, brown skin lady. 81. What's up? Hey, so much Dev. Hey, Tandra. All right, y'all. Okay, so we are here. How is everyone doing? Welcome back to another edition of the Sweet Pea Diaries. We are back with another video. If you are a returning subscriber, welcome back to my channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like this video, share this video, but most importantly, be sure to subscribe to the channel. Oh, thank you, Kevin. I love you too. Listen, look at my girls. Everybody in the chat showing love. Hey, Life with the Leonard family. Hey, Soleil. Hey, Trick Mama. When you know, you effing know. Yes. Okay. Okay. Public service announcement. You've been warned. However, the chat is on subscribers only. And members only. So only subscribers and members are able to comment. We have a lot to unpack tonight. During our first episode of Inside the Lawsuit, for those that have been following this case, we are going to unpack everything that has been happening so far. We are going to go through the documents. We're going to take you on a document page by page journey into the depths of this lawsuit. We're going to get detailed, but we're going to stick to the documents. We're going to read it. We're going to pick it apart, and we're going to give you the breakdown on what's going on with this case. Who's suing, what they're suing for, what is really being alleged in the lawsuit, and there is an update. We have a breaking news update with this lawsuit. There were rumors today that Jennifer replaced her attorney with an attorney that is associated with an attorney that worked for Nicki Minaj on a case that she had about 4 months ago. Well, I did some research. I did some digging. We'll go through that. I wasn't able to correlate if these lawyers are friendly, if they did business together, if they know each other. But I do want to let the public know that it is not the same attorney that represented Nicki Minaj. It is not of the same law firm. Now, if it was an associate or they know each other, lawyers do business together all of the time, that would not be a conflict of interest. Just because an attorney that represented Nicki Minaj knows the new attorney that is representing Jen, that is not a conflict of interest. It would have to be the same attorney. So no, it is not the same attorney. They are not of the same law firm, and I'll show you that proof. We had that paperwork as well. Also, there was rumors that Jen replaced Tyrone Blackburn with a new attorney. A new attorney has entered into the picture. He filed a notice of appearance today, meaning that he's entering into the case. However, there was no withdrawal or notice or intent to withdraw filed on behalf of Tyrone Blackburn. So that does not mean at this point that Tyrone has been replaced. When a lawyer is being replaced and he's not going to any longer represent his client, they have to file an intent to withdraw, a notice of withdrawal, intent to withdraw, whatever it is that you want to call it. But it is a form and a motion that has to be entered into the courts stating that they're intending and asking to withdraw. Because anytime an attorney wishes to withdraw from a case, he has to get the permission of the courts. You can't just withdraw, especially if you are already into the case, if you are already on the case. So there are paperwork that has to be filled out and submitted before the court when a lawyer wants to either withdraw, be replaced. So the only docket that I see, the only document that I saw entered into the docket was a notice of appearance by the new attorney. So that just simply means that she's getting her legal team beefed up. She's adding legal counsel. She's adding another experienced attorney to add to her legal team. There's nothing wrong with that. That's what if she wants to do that, that's her prerogative. So that is what is happening. That is, that's the update. Okay. So I wanted to start off with that and give you guys that update because there were a lot of people speculating that Jen fired Tyrone and that she replaced the lawyer with someone that was part of Nicki Minaj's team, and she's going to lose because it's conflict of interest and all of that. That is, so as of now, through the research that I did using the court documents that are entered. And so this is what I want to show you guys. I want to show you that I am not getting my documents from Google. There are a lot of people that use the court documents And I found today that you are able to Google these docket numbers. And because they are entered on Pacer, the dockets will come up. However, those can be they can be doctored. People can doctor those. People can, add verbiage. So I don't use those documents. I use the documents straight from Pacer. Okay. I get my documents straight from the docket. I don't get anything off of Google because I want the legitimate docs. I don't want anything that's been manipulated. You can use a PDF editor when stuff is found on Google, and people can add and, do all types of adding and stuff. So I do not use Google. All right. I use Pacer. So I will show you where I'm getting my documents from before we get started. Okay. I just want to clear that up. So let me show you my Pacer where it is. All right. So as you can see, this is the Pacer account. All right. This is the actual file. As you see, it says Pacer Service Center. So every piece of document that is entered in this case, you see it says Defendant Onika Mirage and Kenneth Petty. And then at the top, it's Jennifer versus it. Jennifer's up at the top. So, and then on this side, it has their lawyers, who they're represented by. So anytime there is a document entered, a motion, any type of anything, this is where we pull the documents from. Okay. So I just wanted to show everyone that so that you wouldn't think I was getting my documents from Google. I am getting them from the courthouse. These are the court records. All right. All right. So let's get started. So the rules to this live, when we do the court case update, we're only keeping the chat on subscribers and members only. I'm going to ask if anyone has any questions to please save them towards the end of the video when we do question and answer time. We have a lot of information to uncover and read. We are not going to give our opinions during this time. We are simply going to read the docs. I'm going to explain what's going on. And then at the end of the video, we will enter into discussion. I'll put the link out. If anyone wants to come up, they are more than welcome to come up. You will have to verify who you are behind the scenes before you're able to come up so that I can keep everything neat, clean, and orderly. If for any reason that anyone comes in disrespectful, you will be immediately blocked. We are not tolerating it. So moderators, be on the lookout for any trolls, any spam, any fraudulent or fake pages. Immediately block them. We are on high alert because they're going to try to get this video flagged and they're going to try to do all kinds of things to sabotage the channel. So whenever you see anyone, immediately block them. All right, so let's get started. Shall we? Everyone ready? Ready, set, go. Ready, set, go. All right, so we all know that Nicki Minaj and Kenneth Petty are being sued by Jennifer Hough. Jennifer Hough is Kenneth Petty's rape victim from the 90s. The two of them grew up in the same New York, Jamaica, Queens neighborhood where Jennifer was assaulted by Kenneth Petty. As time went on, Kenny went to jail. We all know the story. He gets out, he grows up, marries Nicki Minaj. During all of, prior to that, Jen was harassed. She moves around. He gets with Nicki. They start harassing Jen, the fans. The story, we've heard it all. But we've always heard people's take on it. Well, we're going to look at the documents and pull back the layers to this story. There's been many narratives pushed that Jen is doing this for money, that she wanted to manipulate and extort Nicki Minaj for money, that she was hoping that the case would not go to a jury because she wanted to settle behind the scenes. So there were a lot of narratives being put out before this case before they even started entering paperwork. So the first complaint, which is a complaint, is what you are filing, what the lawsuit is about. The first complaint was entered in and filed into court on August the 13th, 2021. Here's that document. Okay. All right, so it's going to be, all right, you guys know it's a lot, so I gotta find, that's not the right document. It's hard for me to get to them because they're not labeled, so I gotta make sure I pick the right one, so just bear with me. Okay, that's the amended complaint. Give me a moment. All right. No. There's so many documents, guys. I'm sorry. Just give me some time to get to it. All right. Let's try this one. No. All right. You know what I'm going to do? I'm going to do it like this. I'm going to play it safe, and I'm going to pull them up as I get to them. That's what I'm going to do. I'm going to do it like that. That's what I'm going to do. That's what I'm going to do. I'm just going to leave them up one at a time, and then I will get, that's what I'll do. I'll pull them up as I, as I go, and as I go through the story, I'll pull them out the thing. So that way I don't have so many windows open. So that way we'll be able to work faster. All right. So here it is right here. All right. Okay. So here is the first complaint. It was filed into the courts August 13, 2021. This is the original. This is the page that they say it's 27 pages when people were like, it's 27 pages. So this is why I tell you guys, when we're doing this lawsuit, and a lot of people had a lot of, they have a lot of rebuttals. They're not even working with the proper complaint. This is the first complaint. This is not the amended complaint. This is the first complaint. This doesn't even have all of the harassment and what she's suing for, all of the background, all of the things that Jen is alleging. This is what is on Google right now. This is currently what is on Google and what everyone is referring to, the 27-page document. This is not the current document. This is the first complaint that was filed. Now, Jen is demanding a jury trial. She is demanding that this be heard in front of a jury. Okay, as you can see, it's stamped jury demanded. It reads, Plaintiff Jennifer Hough brings claims for witness intimidation, intentional infliction of emotional distress, negligent infliction of emotional distress, harassment, assault, battery, sexual assault, and sexual harassment against defendant Kenneth Petty and Nicki Minaj, collectively known as the defendants, and now allege as follows. Plaintiff's claims include but are not limited to witness intimidation, intentional infliction of emotional distress, negligent infliction of emotional distress, harassment, assault, battery, sexual assault, and harassment and sexual harassment by defendants. Plaintiff seeks to hold defendants liable under various legal doctrines, including without limitation, vicarious liability, strict liability, respondent superior, aiding and abetting liability, and other grounds. So then it goes into what the jurisdiction and venue is, the parties involved, facts common to all causes of actions. So when you get to the facts common to all causes of action, this details the rape and what brought us to this cause of action. What is bringing us to cause this plaintiff to file this lawsuit against these defendants? How do you know Kenny? What is the background? So they go into the background of the rape, the background of the intimidation and indirectly being harassed by Nicki Minaj, her peoples, her lawyers, her goons, her fans. This is all outlined here. What they talked about on Queen Radio, how she manipulated the audience. All of these claims are detailed in the facts common to all causes of action. And the words that I'm using, manipulated, indirectly intimidated, these are not my words. These are words in these paragraphs, in these sentences. So again, we are sticking to the documents. These are Jen's words, what she is alleging through her lawyer. And I also wanted to point out very quickly, I wanted to give you the definition and how legalities are entered into court. When you have an attorney, both sides, the plaintiff and the defendant, the lawyer is speaking on behalf of the attorney. The lawyer drafts these motions. The lawyer drafts all of this paperwork, but it is really depositions. They are really transcripts. They are transcribed by the lawyer, but most of the time the paralegal. The paralegal that works for the attorney transcribes the notes and things, that the conversations that the client is having with the attorney. And that's how they draft their complaint and they put their motions together. So it is not an attorney telling the client what to say and how to formulate their complaint. The lawyer is the one that knows the legalities and how to submit these motions and briefs to court. That is what you use an attorney for. And you use the attorney for advice on how you should plead, how you should go about defending your case, what kind of strategic moves are you going to make, how they're going to approach their defense. That's what you're using an attorney for. So there was some narratives that the attorney tells Nicki Minaj what she should do. The attorney tells Jen what she should do. That is not true. They work together to formulate a plan, and they have to enter these briefs and motions in such a way that is approved by the court. So all these briefs, there are set guidelines for how they have to be drafted and written up. So that's what you see before you. Anytime you see a brief that we are reading, they are formulated in a way that is appropriate for court, that is approved by the court clerk, and she stamps it and it's entered into the docket. Okay? All right. So they're going to also be citing the Child Victims Act because Jennifer was under the age of 18 when she was assaulted. So this is just that act in here. There's no reason for us to read it. Now, factual allegations. Kenneth Petty violently raped plaintiff Hough. This goes into detail about the rape. We're going to really read that when we read the amended complaint, the updated complaint. But I just want to show you that this is the first complaint that was entered. So she details the escape. Nobody's going to believe you. 16-year-old plaintiff immediately reports the rape. Victim blaming. Plaintiff victim blamed by her family. Plaintiff suffers physical violence as a result of Defendant Petty's plea. Plaintiff is chased out of New York City. The ensuing years, Kenneth Petty and Nicki Minaj intimidate and harass the plaintiff. Defendant Minaj uses her celebrity platform to bash the plaintiff. Defendant Petty is arrested for failure to register as a sex offender. Defendant Minaj sends her associates and attorneys to harass and intimidate the plaintiff. Defendant Minaj sends lawyers and investigators to the plaintiff's house. Defendant Minaj sent Black to plaintiff's house. Plaintiff suffers. The United States Marshals contact plaintiff Hough. Plaintiff is contacted by Defendant Petty's legal counsel. Plaintiff moves to Florida to protect her family. Count 1 against Defendant Petty, intentional infliction of emotional distress. Now we start getting into the counts and what she's suing them for, describing it in detail, who it is, where the jurisdiction. So that is what is going on here. All of the different counts and what they're suing for. And then at the end, it's stating that she's demanding a jury trial and then prayer for relief. The end and summarizing the end of the lawsuit and what she wants out of it. Okay? That was entered August 13th. So then there needed to be some amendments. So this brief is 29 pages, 27 to 29 pages. So September 2nd, they enter an amended complaint because they made some changes and they added some things or removed some verbiage. No, you have to put both of them side by side to really see what was amended. So we will remove that one and we will now pull up the amended complaint, and that is the complaint that we will read from. We will read from the amended complaint because that is the most current, updated complaint. It is not this first one that is on Google. All right, so we will get that. I'm getting that right now. Give me one moment. All right. Okay, so here is the amended complaint. And as I state, court documents are public record. They are available to the public on Pacer, or if you want to go to the courthouse directly, you're able to go there and get these records as well. We are not doing anything illegal. We are allowed to gather in an assembly and view court documents. The public has a right to view public records. And everything that we are doing is educational and for viewing and educational and teaching purposes. Jury demanded trial. Plaintiff Jennifer Hough brings claims for witness intimidation, intentional infliction of emotional distress, negligent infliction of emotional distress, harassment, assault, battery, sexual assault, and sexual harassment against defendant Kenneth Petty and Nicki Minaj, collectively known as the defendants. Hold on one second, guys. I got to give my children the keys so they could go to the store. Hold up one moment. Okay, guys, thanks for your patience. So then it says what they are filing. Plaintiff's claims include, but are not limited to, witness intimidation, intentional infliction of emotional distress, negligent intentional infliction of emotional distress, harassment, assault, battery, sexual assault, and sexual harassment by defendants. Plaintiff seeks to hold defendants liable under various legal doctrines, including, without limitation, vicarious liability, strict liability, and respondeat superior, aiding and abetting, liability, and other grounds. Jurisdiction and venue. This court has personal jurisdiction over the defendants under and consistent with the constitutional requirements of due process, in that the defendants, acting directly or through their agents, intermediaries, or apparent agents, committed one or more of the following: the transaction of any business within the state, the making of any contract within the state, the commission of a tortious act within the district, and the ownership, use, or possession of any real estate situated within this state. Give me 1 second. Okay. All right. And so we just basically, the jurisdiction of venue is basically trying to say whether or not the court has power over the parties in their jurisdiction and their venues that are in that jurisdiction. Okay. So plaintiff is a resident of Florida, while the defendants are both domiciled in California. Plaintiff felt the bulk of defendants' action in the states of Georgia and New York. Damages far exceed the $75,000 threshold for diversity jurisdiction. Plaintiff is a resident of Florida and was a resident of the state of New York at 16 years old when raped by Petty. Plaintiff is currently 43 years old. Petty is a rapist, a registered sex offender, a level 2 sex offender, and pled guilty to first-degree manslaughter following gunfire that resulted in the unnecessary death of a young man, according to Petty's sex offender registry. He was born April 7th, 1978, and is currently 43. Defendant Onika Tanya Mirage is a Trinidadian-born rapper, singer, songwriter, and American actress. Defendant Minaj and Petty were married on October 22nd, 2019, as reported on Defendant Minaj's online social media. Defendant Minaj and Petty are both residents of California. Now, facts common to all causes of action. Plaintiff knew Petty from their childhood neighborhood of Jamaica, Queens, New York. Plaintiff was never in a relationship with Petty and simply knew him from the neighborhood. Plaintiff has never personally known Defendant Minaj. In violation of his 1994 plea deal, Petty failed to register as a sex offender in California. The United States Attorney's Office for the Central District of California prosecuted Petty for failing to register as a sex offender. Petty has since taken a plea deal for failing to register as a sex offender. So what this is saying is that the recent failing to register as a sex offender, Kenny pled guilty to that, and in result, he took a plea deal, and we are currently waiting to find out what the results of that and what the consequences and the sentence of that will be. In violation of his 94 plea deal, Petty directly and indirectly intimidated plaintiff not to speak out concerning the rape she experienced at the hands of Petty. So when they say that in violation of his 94 plea deal, that means that the plea deal that he took for assaulting Jennifer and the charges for that, there has been some discrepancy about rape versus attempted rape. That he was not convicted of rape, he was convicted of attempted rape because the state and DA somehow knew that he was not guilty and that it really wasn't much that they had on him. So because they wanted to railroad him as a young black man and a young black boy and make him do time for a crime that he committed, they wanted him to be in jail. And so they offered him a plea deal. And so instead of calling it rape, they called it attempted rape. Well, that is not true. That is a false statement. He was convicted of attempted rape because he took a plea deal. We have no way of knowing why he took this plea deal. We have no way of knowing whether or not his parents told him to take it or not, because we don't have the transcripts. No one has seen those because it happened to a minor. Those records are sealed. They are nowhere. No one has them. And if they have them, they were given directly from him or someone that knows him or someone that is in that camp or someone that would be in the court, because records of minors are sealed. Those are not available to the public. So no one knows whether or not his parents said this or what the verbiage was. Now, I can tell you from previous cases and other instances and my experience with the justice system that when someone takes a plea deal for a very serious crime, in order to get that person lesser time in jail, they have to lower the offense. So for Kenny to do 4 years for rape, first degree, assaulted, aggravated, whatever you want to say, that would have carried a very large sentence, 10 to 15 years even, 20 years maybe. So because they wanted to offer him a plea deal, they didn't want to ruin this young man's life. They realized he was a young child still and that he still had his whole life ahead of him. They offered him a plea deal, lowered the charges to attempted rape, so that way he could get 4 years. That is the only way they would have been able to lower the time. You cannot give someone a plea deal on a very violent rape charge. It doesn't, that does not add up. In order to get a plea deal, they got to knock the offenses down, they lower the charges, and they give you less time. That is so that it saves the sake of a trial, and it helps the person, because if you take it to trial, you run the risk of being found guilty before a jury of your peers, and you run the risk of getting more time and being in jail longer. So that is what plea deals are all about. And that's what they are meant to do. Help someone get lesser time, get out of jail faster. You plead guilty, take this time and be done with it. You got, and the part of that he violated, you are not allowed to have direct contact or indirect contact with the victim. You cannot talk to them on the phone. You cannot write them. You cannot send other people to them. You cannot DM them. You cannot text them. You cannot use your friends to contact them. Indirectly or directly, you are not allowed to have any contact with the rape victim. You are also required to register as a sex offender whenever you go to different jurisdictions. So Kenny was doing that up until 2019, 2018, 2019. He was doing that. But once he started dating Nicki Minaj is when things took a turn. So in violation of his 1994 plea deal, Kenneth Petty directly and indirectly threatened the plaintiff not to speak out concerning the rape she experienced at the hands of Petty. In violation of the 1994 plea deal, Petty directly and indirectly harassed the plaintiff not to speak out concerning the rape she experienced at the hands of Petty. In violation of the 1994 plea deal, Petty directly and indirectly reached out to the plaintiff's family members to ensure that the plaintiff would not speak out concerning the rape she experienced. Defendant Nicki Minaj indirectly attempted to intimidate plaintiff into recanting her legitimate claim that Petty raped her. So when people say that Jen said that Nicki did not contact her, she says it right here in the brief as well. Defendant Nicki Minaj indirectly attempted to intimidate plaintiff into recanting her legitimate claim that Petty raped her. So when a person indirectly attempts to intimidate you, they do not have to do that by contacting you. They can do it through all sorts of ways. They can do it through social media, by taunting you, by sending indirect messages, by sending subliminal messages, by using other people to send messages, by using fans to perpetuate narratives and false stories. So that's what they're meaning when they say indirectly. Number 21, defendant Nicki Minaj directly and indirectly harassed the plaintiff to recant her legitimate claim that Petty raped her. Defendant Nicki Minaj indirectly threatened plaintiff to recant her legitimate claim that Petty raped her. Defendant Nicki Minaj directly and indirectly reached out to the plaintiff's family members to ensure that the plaintiff would recant her legitimate claim that Petty raped her. Defendant Minaj lied to her social media followers and Queen radio listeners about what transpired when her spouse Petty raped plaintiff to prevent her rapist spouse from registering as a sex offender in California. Now, there has been mention that Jen has not put forth any proof. There were several questions asked previously. Where is the proof? Where are the receipts? Where is the proof that Nicki harassed her or Kenny harassed her or Black or others harassed her and threatened her, her family? Where is the proof? So when you are in a legal battle and you are in a lawsuit, there are different phases of the lawsuit. The phase for evidence to be submitted is called the discovery phase. During the discovery phase, you enter exhibits, you answer interrogatories, you answer deposition, the deposition phase is also prior to discovery. Deposition phase is also a phase of a lawsuit. Okay. So during the discovery phase, that's when they're going to bring about the discovery. Okay. So there are 3 phases of a lawsuit. Okay. So that's what I want people to understand. You have to understand what goes on when you file a lawsuit. This is not, and I don't mean to sound sarcastic, but this isn't the first 48. This isn't 48 hours. This is not Perry Mason. This is not a TV show. This is not Forensic Files. This is a court of law. This is real life. So the 3 stages of a lawsuit. The first stage is the pleadings. That's when the initial documents that start the lawsuit and outline the claims, the counterclaims, the defenses of each side. That's when that is heard. Okay. Then comes the discovery. So right now, where we are in the pleading stage. We are nowhere near the end, the trial, any of that. We are at the pleadings stage when everybody is entering their documentation, pleading what they're going to plead. And Nicki Minaj, at this point, she had not answered to the lawsuit. So she had not even answered and put forth a plea. We know that she was late with her plea or her response to the lawsuit. All right. So the next stage after the pleadings is the discovery phase. And during the discovery phase, the parties mutually exchange factual information during discovery. During that time, that is when your evidence and what you're going to use to defend yourself, that is what is done during that time. It is the pre-trial phase of a lawsuit. And during that time, each party investigates the facts of the case. And they do that by obtaining evidence from each party. So from the opposing party, from the defense, from the plaintiff, including requests to answer interrogatories, requests for production of documents. So that is how you get the evidence entered into the lawsuit. Remember when we covered Tasha K and Cardi B and we made joke about interrogatories? Well, that is part of the discovery phase. You have to request that this side enter this side give proof of that. We want evidence of the phone calls, the directly and indirectly. You need to show proof that Nicki Minaj was harassing you. You need to show proof that Kenny was harassing you. Where is your proof? Jennifer has to show burden of proof that they were harassing her. So then that is when that will come into play during the discovery phase. During the duration of the discovery phase and the discovery process, typically, this is the most time-consuming portion of a lawsuit. Usually, it takes about 6 months to a year, and sometimes longer in the discovery phase, because That's when each side gets into the meat and potatoes and they start arguing back and forth. They start asking for this. I want this. You need to answer to this. You need to answer to that. You need to do back and forth. Okay. All right. And then after that, we reach the conclusion. And during the conclusion, that is following the actual discovery. And that's usually when you can either settle with a mediation, like outside, or that's when you're going to actually go into trial. That's when you'll actually go in front of the jury, and then we'll reach a conclusion. Okay? So it's very important to know what you're dealing with and what a lawsuit is all about before you start making judgments and before you start saying, well, this is this and this is what happens. You have to stop thinking that everything is TV. That is not how it works. All right? So let's keep it moving. So as a direct result of the actions, Defendant Minaj and Petty, plaintiff has been traumatized her entire life. Plaintiff has been abused and manipulated her entire life. Excuse me, 1 minute. Plaintiff has been abused and manipulated her entire life. Plaintiff has been harassed and intimidated her entire life. Plaintiff has never felt safe since being raped by Kenny. Plaintiff has moved to multiple states to avoid intimidation and harassment by Defendant Minaj, Petty, and their allies, legal teams, and fans. Now, of course, when Jen says she's been traumatized her entire life by Minaj and Petty, she's been manipulated her entire life, abused, they are not figuratively speaking and stating that they have intimidated her entire life. Of course, we know that they could have not done that. That is court lingo. That is just a blanketed statement. That is just courtroom jargon, legal mumbo jumbo, because we know god darn well that they did not do that their entire life. They were kids, babies at a point in some time. So we know that that is courtroom jargon. So please do not be, how could they do that her entire life? Please don't go there. That is courtroom jargon. Google entire life, courtroom lingo, and you will learn what it means. So as I stated, as you go down, you see that they're intending to use timeliness under the Child Victims Act. They're going to reference Child Victims Act in this case because Jen was under the age of 18 when this occurred. Now, factual allegations that Kenneth Petty violently raped plaintiff Hough. September 16th, 1994 is a date now burned into plaintiff's memory and soul forever. Plaintiff, a 16-year-old girl, left her grandmother's house in Jamaica, Queens, and was headed to the Q7 MTA bus stop on 145th Street and Walkaway Boulevard to catch the bus for school. Petty was standing at the bus stop when plaintiff got there. Petty was known as a delinquent that opted not to go to school, instead choosing to spend his days scouring the streets of Jamaica, Queens. On September 16, 1994, when plaintiff arrived at the bus stop, she was taken aback at the sight of Petty waiting at the bus stop. Petty's custom is to stand outside the store across the street from the bus stop, not the bus stop itself. Plaintiff stood at the bus stop but did not address Petty. Defendant Petty asked the plaintiff, "Where are you going?" To which the plaintiff responded, "To school. Where are you going?" To which Petty answered, "I'm going to school also." Plaintiff did not believe him because she knew Petty never went to school, so she responded, "Yeah, right." After that brief exchange, plaintiff turned her back to Petty to look to see if the Q7 bus or a dollar van was coming. As she turned her back, Petty approached her from behind. Petty grabbed the back of plaintiff's jacket firmly and pressed a knife into her back and told her to start walking. Plaintiff tried to turn around, but Petty would not let her go, nor would he take the knife from her back. Plaintiff began pleading for her life. Kenny, where are we going? Kenny, please just let me go. Petty did not let her go. He already made up in his depraved mind that he was going to rape the plaintiff. Petty walked plaintiff to a house around the corner from the bus stop, not letting go of his grip on her clothing, and with the knife still pressed firmly into her back. Petty kicked the door to the house open, pushed plaintiff inside, and walked her upstairs, still at knife point. Plaintiff was crying the whole way up the stairs, pleading for her life, absolutely terrified of what will happen to her. Plaintiff pled to Petty, "What do you want from me? Why am I here?" Petty replied to her as she pled through her tears, only stating, "You know what I want." Plaintiff ensues in a struggle with Petty, fighting for her life to get this rapist off her. Petty held her down with his body weight and used his hands to forcibly rip off her pants, prying them off her small 16-year-old frame. Plaintiff was fighting back with all the strength she had. Then Petty grabs the knife again, presses it into plaintiff's stomach, causing a small cut, and threatens to use it further. Petty begins to squeeze plaintiff's sides to force her to let go of her pants. After being threatened with a knife cut on her stomach, plaintiff had no fight left in her. Seeing no escape in sight, plaintiff did the only thing she could do to save her life, and that was to give in and hope her rape would be over quickly. Once Petty got off plaintiff, he stood in the mirror and beat on his chest, stating, "I'm the man, I'm the man." Now, yesterday, I want to make a point of why I don't like to be interrupted when I'm doing my live. Yesterday, we had a particular content creator, and I believe an accomplice of hers, come into the chat and wanted to make reference to sentence 41 through 43 or 47 or whatever. And they wanted to make an observation that there was a typo on the documents. That, which one was it? That you said he took the knife and that he pried your pants off with the knife in the hands, but then he pried your pants off as he ripped them off the body. They wanted to make some type of, I don't know, reference to that. But what I want to, point out is that the paperwork they had was from Google. They don't have the amended complaint. They were reading from the original complaint, which probably had typos in it, which is why Tyrone filed an amended complaint on September the 2nd, because they realized that there was some typos and that maybe they might have confused the sentences, or that maybe it didn't look right, or, maybe they were rushing when they were typing it and they didn't have it worded right. And usually when you're drafting something, that might happen. So I think that maybe this second complaint that was entered, amended complaint. That's why it's very important that when you do your research and you do these videos, you use Pacer directly and you get your documents directly from Pacer. So that way you can have the most accurate and up-to-date documentation. I'm going to show you on Google where these documents are. All right. So I'm going to show you where they have these documents, and these are the documents that people are using. They are on digitalmusicnews.com. They are not from an actual court website, okay? I'm going to show them to you now. And I just wanted to point this out because it's very important that you use legal documents when referencing this case. So if you put into Google Kenneth Petty lawsuit documents, right? And you scroll down here, you see the case. You click on it, and it gives you the documents, right? And if you scroll down to where we are, sentence 41, you will see the difference. You will see the difference. Sentence 41 here says Defendant Petty held her down with his body weight and used his hands to forcibly rip off her pants, prying them off her 16-year-old frame. This document is filed August 13th, 2021. Do you see that? These are the old documents. These are not the amended, up-to-date documents. So when people are doing their videos and they came over here and, they wanted to try to poke holes in the story and things like that, they were using old documents. They were not using documents from Pacer. They were using them from Google. These documents could be manipulated. Now, when you go onto the amended complaint, and I'm going to show you that so that you can't say that I'm making this up. When you go to the document on Pacer and you go to the amended complaint, the most up-to-date complaint, you will see that sentence 41, and this is filed September 2nd, the most amended complaint. Sentence 41 is Petty kicked the door to the house open, pushed plaintiff inside, and walked her upstairs, still at knife point. Plaintiff was crying the whole way up the stairs, pleading for her life, absolutely terrified of what would happen to her. That is sentence number 42 in the updated complaint. In the old complaint, sentence number 42 reads, Defendant Petty, number 41 on the new document is Petty kicked the door down to the house open, pushed the plaintiff inside, and walked her upstairs still at knife point. Sentence number 41 on the old complaint says this. Now you see the new complaint, what sentence 41 says, right? Now let's go to the complaint that they were reading from when they came and attacked me yesterday. They're reading from Google documents. We were reading from the old, I never could get to the amended complaint because they interrupted my video. So I never got to show them that they were reading the wrong documents. So when you go to the old documents, sentence number 41 is Defendant Petty held her down with his body weight and used his hands to forcibly rip off her pants, prying them off her small 16-year-old frame. On the amended complaint, that is not mentioned till sentence number 45. So these documents that they are using to do their videos, they are old. They are not the documents that are going to be used for this court case. You have to go off of the amended complaint. You can't use the old one. That is not what is going to be used. Okay? So we proved that point. Now let's keep moving. So on the Sweet Pea Diaries, you will get actual court documents. They will be up to date. What is being filed in the court of law, they will not be Google Docs. They will be Pacer documents. All right? So he stood in the mirror and said, "I'm the man, I'm the man." The escape. Plaintiff mustered all her strength and courage to get back up once again and ask Petty, "Can I please leave?" Plaintiff attempted to walk towards the door and was blocked by Petty, who prevented her from leaving. All the plaintiff could do at this point was to beg and plead to her rapist for her freedom. "Please let me go. I promise I won't say anything. Saying anything to get out of that house." Petty is still admiring himself after the violent rape in the mirror and attempts to light a cigarette to celebrate his depravity. Quickly thinking, plaintiff said, "Let me light it for you." She lights the match and attempts to throw the lit flame towards a roll of toilet paper on the dresser in front of her in hopes of setting the toilet paper ablaze. The flame goes out before it reaches the toilet paper roll. She then grabbed a contact solution container on the dresser. She threw it with whatever strength she had and left at Petty's head. As Petty ducked from the contact solution, plaintiff pushed him with all her might. He fell and she sprinted down the stairs. "Nobody is going to believe you." Petty quickly gets up and yells down the stairs as plaintiff is running, a sentence that has followed her for the rest of her life. "Nobody is going to believe you." 16-year-old plaintiff immediately reports the rape. Plaintiff did not stop running, and she sprinted at least 20 blocks until she reached John Adams High School. Once there, she informed the school security guards of what happened, and they immediately contacted the police. Once the police arrived, they questioned the plaintiff. They placed her in a van to go to the house to confirm the location of her rape and to arrest Petty. Petty was still in the house where he raped plaintiff, and he was arrested on the spot. Plaintiff confirmed his identity, and then the police took Petty to the police station and took plaintiff to the hospital to get checked out. Victim blaming. Plaintiff's friend brought her home from the hospital, and this was the first of many people who victim blamed her. Hours after being violently raped, plaintiff's friend said, "I'm sorry you got raped, but you should have screamed." The day after their son raped plaintiff Petty, the day after their son raped the plaintiff, Petty's parents showed up at the plaintiff's house, beginning the chain of never-ending lies and harassment the plaintiff has had to face. In a clueless, delusional rant, the parents of Petty stated that the plaintiff was only accusing Petty of rape out of anger. Petty's parents claimed that Petty no longer wanted to date the plaintiff. Plaintiff never dated Petty, nor even knew him aside from seeing him in the neighborhood and hearing about him via word of mouth. They were never romantic in any way before Petty raped her. Petty's parents even took the plaintiff to the Queens District Attorney. They pretended to be plaintiff's aunt and uncle to get plaintiff to drop the charge against Petty. Now, there was a discrepancy. There have been some questions surrounding this occurrence. How could Petty's parents take her to the DA's office, who was pretending to be his parents when they took her to the DA's office? I do not understand that question. This was not during the trial. This was prior to the trial. His parents went to her home and got her because her family was also wanting her to drop these charges. So they went along with that as well because they wanted to show that they were helping the defendant so that they would not be harmed. Plaintiff is victim blamed by her family. Shortly after the visit from Petty's parents, the plaintiff's household began receiving death threats. Rumors circulated in the neighborhood that something would happen to the plaintiff if she did not drop the charges. Jamaica, Queens is a tough neighborhood, and threats of that nature are not taken lightly. At this point, the plaintiff's family is beginning to turn on her because they did not want any violence from Petty and his associates brought to their doorstep. Plaintiff, a 16-year-old girl, felt more alone than ever before. Plaintiff had just been brutally raped. She could not go outside without the fear of being retaliated against for telling the police. And now she's afraid to be home because she was being threatened by outsiders for telling the police and by her family for bringing violence to their home. Plaintiff was constantly beaten and verbally abused in the street and her home because everyone wanted her to drop the charges against Petty. Now, we did an interview with CY on the channel, who is a friend, ex-friend of Kenneth Petty and Nicki Minaj and people in that neighborhood. And he has claimed that he was part of that campaign. He also threatened, he was a part of the threatening of Jen back then. He was part of the neighborhood bullying and threatening Jen. If she don't drop the charges, something's going to happen to her. He vouched for this story. I'm just saying, I'm not siding with anyone. I'm just pointing it out that this man has come out risking his own freedom by injecting himself in this situation and saying that he did that. Plaintiff suffers physical violence as a result of defendant Petty's plea. On the day of Petty's criminal proceeding, plaintiff's family forced her to go to the hearing, even though she didn't have to be there. She was not testifying because Petty had already taken a plea deal. Plaintiff hid in the stairwell the whole time, mentally in shambles. The Queens District Attorney happened to take the stairs that day and ran into the plaintiff sitting in the stairs, asking what she was doing there. Plaintiff told the truth and said, "They are forcing me to drop the charges." The DA responded that she would handle it. When everyone was in court, the judge asked if anyone had anything to say, and the plaintiff stood up and stated that she wanted to drop the charges. The judge did not find that statement very convincing and stated, "Take that up with the district attorney." Plaintiff was beaten at home that day because she was not convincing enough for the judge. The family was afraid of what would happen because Petty was now facing prison time. Now, I just want to outline that if you are already taking a plea deal and if the state has picked up your case, there is nothing that anyone can do. The victim cannot drop the charges because the state has picked up the case and they already offered the plea deal to the defendant, which he took already. So there's nothing that she could do. There is nothing that anyone could do at that moment. Even in cases of domestic violence, when a victim tries to drop the charges against her abuser, if the state has picked it up, they will not let them. The state will move forward with the charges and they will lock the man up or they will give him whatever punishment. But once the state picks up something, you can't drop charges. And the only reason why she attempted to drop the charges is she's saying in this lawsuit that her family was making her do it. So the whole trying to recant, it was based off of being threatened. That's what this lawsuit is saying. That's what Jen is saying. She's saying that she was only trying to do it because her family made her do it. Plaintiff is chased out of New York City. Due to the mental trauma from the ordeal, the constant beating and verbal abuse at home, plaintiff ran away from New York City and moved to Florida with her uncle, whom she thought would protect her. Her uncle ended up raping her shortly after her arrival. Plaintiff left her uncle's home in Florida and has been on her own ever since. The ensuing years, plaintiff was mentally and emotionally destroyed and attempted to find value and kindness in anything she could. Partying, drugs, living in the streets, in and out of shelters. Plaintiff's self-worth was at zero. Her emotions were empty and she was lost. Plaintiff moved around a lot because she was afraid to go back to New York for fear of someone recognizing her. Plaintiff had 4 children, numerous failed relationships, and never knew a true home in her entire life. Kenneth Petty and Nicki Minaj intimidate and harass the plaintiff. In 2016, plaintiff moved to Atlanta, Georgia, where she met her husband, whom she wed in 2018. She was finally beginning to love herself and learn to be happy. In 2018, Defendant Minaj posted that she was doing a turkey giveaway in Queens, New York, on Rockaway Boulevard at 147th Street. This attracted much attention, given how big of a star Defendant Minaj is, and since Queens was her hometown. On November 25th, 2018, Defendant Minaj posted a picture of her and Petty, the man who raped plaintiff at knife point. It appeared that they were dating, and in the photo, they were throwing up gang signs. Toward the end of November, Defendant Minaj posted another picture of her and Petty and replied to a comment stating, Kenny was 15, she was 16, and in a relationship, but go off internet. This was picked up by every publication, tabloid, iHeartRadio, USA Today, bloggers, and YouTubers. As a result of Defendant Minaj's post, plaintiff was sought after for comment. Seeing no choice than to defend the truth, plaintiff recorded an interview with a YouTube blogger giving her side of the story. Plaintiff thought that would be the end of it. Defendant Minaj uses her celebrity platform to bash the plaintiff. In November 2019, Defendant Minaj did a show called Shade No Shade on Queen Radio. She repeated the same comment that Petty was 15 years old, but now added that he was wrongly accused. He did not have bail money, and said that plaintiff had written a letter recanting her statement, but would face 90 days in jail if the plaintiff had done so, which was all false. Defendant Minaj also stated, but white is right, because plaintiff is biracial. These statements by Defendant Minaj put social media in a frenzy, trying to figure out who the plaintiff was, if she was a white woman, and where she currently lived. So when they say that there are discrepancies, it's not that there are discrepancies. This is the same story. It is the Queen radio interview. It is the same interview. There were no 2 or 3 or 4 interviews. There were 2 Queen radio shows. There was this Queen radio show where she said what she said, but then there was that photo where the fan replied under it about the rape. That was not on Queen Radio. So when people they try to make it like there were multiple shows and that Tyrone and the briefing is trying to make it seem like there were multiple shows and that they are lying. No, when you write a brief, if you notice when I was reading all of the earlier stuff, they repeated the same statements over and over, and they described the same incident in different areas of the lawsuit. They go into detail more when they go, in certain areas, or this side, it might be more in detail. But if you know anything about this, the Queen Radio interview, it was only one Queen Radio. This is what they're talking about in November of 2019, when she went on there and she said, white is right. He didn't have bail money, all that. When she said under that caption, y'all, but go off internet, you can't control my life, y'all can't even run your own life, that was not Queen Radio. That was a post on Instagram. Okay? Kenneth Petty is arrested for failure to register as a sex offender. In March 2020, Petty was arrested for failing to register as a sex offender in California. A few days after the arrest, the plaintiff was contacted by an old childhood friend, Black. They caught up, and the topic of plaintiff's rape came up, to which the plaintiff stated she wished it could all just go away forever. Black responded, I can make that happen. A few days later, Black called the plaintiff and informed her that Defendant Minaj asked for plaintiff's phone number and that he had given it to her. Shortly after that, Defendant Minaj called the plaintiff. During the call, Defendant Minaj stated she heard plaintiff was willing to help out their situation and stated she would fly the plaintiff and her family to Los Angeles. Plaintiff declined this offer. Defendant Minaj then stated she would send her publicist to meet with the plaintiff to craft a statement recanting plaintiff's rape charge. Plaintiff denied this offer as well. Before they got off the phone, plaintiff said to Defendant Minaj, I need you to know, woman to woman, that this happened. Defendant Minaj hung up the phone. Within days of this conversation, plaintiff and her family suffered an onslaught of harassing calls and unsolicited visits. Now, a couple people asked previously when we were doing videos, well, where's the proof of this? Again, when we get to the discovery phase of the trial, that's when we will see what evidence, if any, that Jen has. If there were harassing phone calls, if there were messages, if she taped it or did any of that, this is when that will be entered during the discovery phase. We are only in the pleading stage of this trial, or lawsuit, should I say. We are not at discovery. There are no interrogatories. There's nothing. We are only at the pleading stage. Okay? So if she called and Jen has any evidence of that, it will be submitted during the discovery phase, which is coming up next. That is going to be the next phase that this lawsuit enters. And when we enter that, they'll enter it in on Pacer and I'll be able to see it. But as of now, they are not at the discovery phase yet. Defendant Minaj sends her associates and attorneys to harass and intimidate the plaintiff. A few days after Defendant Minaj called the plaintiff's brother called her. He stated 2 people reached out to a family member stating there is an offer of $500,000 from Defendant Minaj if the plaintiff wrote a letter recanting her rape claim against Petty. Plaintiff hung up, distraught that Defendant Minaj instructed her associates to contact her brother, and her brother would even relay such a message. This act by Defendant Minaj and her associates caused plaintiff to panic because Black, who was in contact with Defendant Minaj, now knew where the plaintiff lived, where plaintiff worked, and the identity of plaintiff's kids. Defendant Minaj sends lawyers and investigators to plaintiff's house. In April 2020, on behalf of Petty, fact finder investigator Charles Mittelstalt from Georgia contacted the plaintiff. He put plaintiff in contact with an attorney named Ian Wallach from New York. Defendant's legal team hired attorney Wallach to give plaintiff legal advice about recanting her statement. Attorney Wallach stated he was the plaintiff's lawyer and anything said to him was protected under attorney-client privilege. Plaintiff did not know attorney Wallach and had not reached out to him for legal services. Plaintiff told attorney Wallach Defendant Minaj and Petty was sending people to her home and to the homes of her loved ones to get her to recant her true statement that Petty violently raped her. Plaintiff told attorney Wallach that the defendants were harassing her. Attorney Wallach promised to help her, but his efforts were lackluster at best. Defendant Minaj sent Black to plaintiff's house. Black continues to receive and relay messages from the defendants to plaintiff. For a while, plaintiff ignored Black's calls. Plaintiff finally answered, and he tells her that he had good news. Black stated that nothing would happen to plaintiff if she signed and notarized some papers he had in his possession. Shortly after the call, plaintiff appeared in front of plaintiff's home. To protect her children in her home, plaintiff met Black in front of her house in his car. While in his car, Black pulled out a green-colored folder that had a document inside. This document was a written recanted statement prepared for the plaintiff to sign. Black then pulls $20,000 out of the armrest and places it on the plaintiff's lap. Plaintiff took the money off her lap and placed it on the floor. Plaintiff could not believe that Defendant Minaj would go this far to bribe her. Black even said that Defendant Minaj would also send happy birthday videos to plaintiff's daughter for her birthday as a bonus. So Nicki Minaj was going to sing happy birthday or do happy birthday videos to Jen's daughter for her birthday as a bonus favor if she recanted her story, signed the paperwork, and took the $20,000. That's what that sentence reads. Plaintiff suffers. During these unsolicited calls, contacts, and communications, plaintiff is having nightmares. The memories began to flood Black from the date of her rape. She begins to experience anger, pain, sorrow, anxiety, and trust issues. The plaintiff starts having crying fits and thoughts of paranoia. At the end of May 2020, plaintiff received a call from her brother where he was speaking frantically. The brother stated that they now knew where she lived, what her daughter does, and threatened to have someone else show up at the plaintiff's house if she did not recant her 1994 rape claim. After receiving this threat, plaintiff moved in June of 2020. She changed her phone number, registering her new number under her husband's name. These efforts by plaintiff were unsuccessful in curbing the harassment and unwanted contact. Shortly after changing her number, plaintiff was contacted by a lawyer who was instructed to reach out to her by Defendant Minaj. Plaintiff became so paranoid that she moved again in August of 2020. The United States Marshals contact plaintiff Hough. 3 days after moving in August 2020, the U.S. Marshals showed up at the plaintiff's husband's job. She called the U.S. Marshals and they stated that someone had called them to report that plaintiff was being harassed and they were worried about her safety. The Marshals offered plaintiff witness protection. The Marshals also confirmed with plaintiff that the call she received from California was indeed Defendant Minaj. Now, this statement right here is where I struggle with the most. In my experience, I have never known U.S. Marshals to act in this way. I have always known U.S. Marshals to be sort of like bounty hunters. They usually go after people that are absconding from justice. You know, they usually help in fugitive cases. So I am a little surprised that the Marshals would show up and offer her this service. So I'm expecting and anticipating proof of that. I can't wait to see during the discovery phase what they show as proof of that, because I would like to see that as well. I don't take from anything that Jen is saying, but as far as my experience about the Marshals, I was a little taken aback about that because I've never known the Marshals to do that. I've always known that the Marshals, they just go pick up fugitives from justice. They're more, you know, they go pick up people that are murderers and that have been on the run. You know, they're very high level law enforcement. U.S. Marshals, they the ones that got on jeans, boots, honey, got their badge on their hip. They mean business. When you get a visit from the Marshals, they mean business. So if they came to her, this is serious. Okay? So I can't wait to see what we have in store for that. I am anticipating discovery, child. I can't wait for the discovery phase so I can have a fields day looking at all that evidence. Woo, child. We're going to have a watch party that night, child. When we get the discovery, you guys, we're going to have a watch party. When we get to comb through all of that evidence, we're going to have a fields day. Plaintiff is contacted by Kenneth Petty's legal counsel. In September 2020, while visiting her brother in South Carolina, plaintiff is once again harassed. Plaintiff gets a call from a New York attorney stating that they represent Petty. The attorney states they were trying to go to court to get Petty off the sex offenders registry and asked about the recantment letter and if plaintiff wrote it. Plaintiff Hough moves to Florida to protect her family. In October 2020, plaintiff's daughter was at an event in Atlanta, Georgia. At the end of the night, plaintiff's daughter and her friend group were approached by a man. The man asked, "Do you know Zoo?" Zoo is Petty's street name. Plaintiff's daughter yelled at the man and left with her friends. Not even plaintiff's daughter was safe from the intimidation tactics and harassment by Defendant Minaj. After this incident, the plaintiff again feared for her and her family's safety. So she moved again, this time to Florida. She was afraid for her child and afraid that her child would be killed or kidnapped due to the threats from Defendant Minaj and Petty. In November of 2020, plaintiff put a YouTube video out speaking about everything she had been going through in hopes of creating a digital footprint just in case something was to happen to her. Bloggers caught wind of the YouTube video and began victim shaming her, telling their audiences that plaintiff was lying, that she was just a white woman trying to make a quick dollar out of the limelight. Defendant Minaj's fans claim Nikki said it was a lie, so it is a lie. Plaintiff has not worked since May of 2020 due to severe depression, paranoia, constant moving, harassment, and threats from the defendants and their associates. She is currently living in isolation out of fear of retaliation. Defendant's intermediary publicity threatens plaintiff Hough. Oh, wait a minute. What did I say? I'm getting sleepy, y'all. My tongue getting tied. Defendant's intermediary. Oh, they're intermediary. Defendant's intermediary publicly threatens plaintiff Hough. Now, y'all know I'm tongue-tied now. I done read so many documents. Oh, thank you, Jasmine. Thank you for the $4.99. Child, I'm tongue-tied. So, defendant's intermediary publicly threatens plaintiff Hough. On or about August 12, 2021, within days of Petty reaching a plea agreement in the Central District of California for his failure to register as a sex offender, defendant's intermediary, Black, posted a threat to plaintiff on his Instagram social media account. In the post, Black said, "Case is over now," referring to the federal criminal case Petty accepted the plea deal for in Central District of California. The video went on to say, "John Wayne TV coming soon. Tell that bitch she will be expose case over now. 20K, huh? You know you done fucked up. John Wayne TV. You lying ass bitch. 20,000. Black ends the montage with a photo of two guns circled with the words, "Be safe out here, LOL." And then they have the photo in Exhibit B. So let's go on down to Exhibit. Is that in here? Child, is that in here? Do they got the exhibits in here, child? Oh, yes. Here's Exhibit A, which is when we talked about that, what kicked off in 2019 when Nikki was posted up with Kenny. And she said, "Oh, they want to talk? Let's give them something to talk about," in my Shania voice. And then that's when that fan said, "Wait, y'all calling this man a rapist, but it happened in 94, meaning he was 16 or 17, and the girl was a 16-year-old. Must have been a white girl." And Nikki said, "At Anadol, he was 15, she was 16, in a relationship, but go off internet. Y'all can't run my life. Y'all can't even run y'all own. Thank you, boo." And then this is Black Exhibit B, where he got the guns on his lap. "Be safe out here, LOL." And he was saying all what he was saying in that. Child. All right, let's get back up there. Okay. Black ends the montage with the photo of the two guns circled with the words, "Be safe out here, LOL," written on the photo, Exhibit B, which we just looked at. In fear for her life and safety, plaintiff filed a police report in Florida and has since moved to another state out of fear of being found and killed by Petty or one of his intermediaries. So now we are going to get into Lady Libra says the Marshals is in charge of witness security, which includes witness intimidation. I actually wasn't surprised about that part. I was relieved. Okay, awesome. I didn't know that that was a part of their office. So that's great. So I can't wait to see the discovery so we can, oh girl, we're going to have a Phil's Day when that comes. When we have discovery, when we enter the discovery phase, we'll get to see what evidence is being put forth to show harassment. So now we get into the counts. Count 1 against Petty, intentional infliction of emotional distress. Plaintiff repeats and realleges by reference all paragraphs above as though fully set forth herein. To state a claim for intentional infliction of emotional distress, a plaintiff must plead extreme and outrageous conduct, intent to cause or disregard of a substantial probability of causing severe emotional distress, a causal connection between the conduct and injury, and severe emotional distress. So then they cite other cases that cited intentional infliction of emotional distress. With court cases, they use historical cases to show evidence and compare how they plan to show intentional infliction of emotional distress, just like these cases did. So that's why they use cases in comparison. Petty's extreme and outrageous conduct alleged in this complaint, including but not limited to sexual assault, rape, harassment, and intimidation, was intentionally and maliciously committed with intent to deliberately inflict humiliation, mental anguish, and emotional and physical distress upon the plaintiff, and done in wanton and reckless disregard of such consequences to plaintiff. As a direct and proximate result of said extreme and outrageous conduct by Petty, plaintiff did suffer humiliation, mental anguish, disassociation, suicidal ideation, and emotional and physical distress, and have been hurt and injured in her health, both mentally and physically, strength, activity, and her ability to lead an everyday life without mental anguish, all of which have caused, continue to cause, and will continue to cause plaintiff great mental and physical pain and suffering for the rest of her life. As a result of such severe emotional and mental distress, plaintiff has been generally, especially and consequentially, damaged in an amount to be established according to evidence. Petty's behavior toward plaintiff was so outrageous as to exceed all reasonable bounds of decency. Petty knew with substantial certainty, or should have known, that his behavior would cause plaintiff to be a victim of sexual assault, sexual abuse, and sexual contact. Petty knew with substantial certainty, or should have known, that his behavior would cause severe emotional distress to plaintiff. Petty committed the infliction of emotional, physical, and mental distress willfully and intentionally and through coercion, oppression, fraud, and malice, and consciously disregard plaintiff's rights. Therefore, plaintiff is entitled to an award of exemplary or punitive damages in an amount to be established at trial to meaningfully punish Petty, thereby deterring similar conduct in the future. Count 2 against Petty, assault and battery, New York. Plaintiff repeats and realleges by reference all paragraphs above as though fully set forth herein. Petty, through the conduct described further herein, created an unwanted threat of violence against plaintiff. Petty's conduct was made with the intent to provoke observation of the threat and cause a reasonable observation of the immediate danger. Petty has and possesses the present capacity to bring about violence. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, loss of enjoying life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Petty's actions and omissions warrant an award of punitive damages. Recovering damages for an assault requires proof of physical conduct, placing the plaintiff in imminent apprehension of harmful contact. To recover damages for battery, a plaintiff must prove that there was bodily contact, that the contact was offensive, and that the defendant intended to make contact without the plaintiff's consent. Petty committed a battery against plaintiff because he intentionally engaged in unlawful, intentional, and offensive touching or application of force to plaintiff's person. Here, Petty committed several acts of battery. Petty grabbed plaintiff from behind and placed a knife in her back. Petty cut plaintiff with the knife on her stomach as he wrestled with her to remove her pants. Petty grabbed plaintiff by her sides to inflict pain, to cause plaintiff to release her pants. So this is that whole discrepancy that they were trying to, which one was it? How did he grab at her sides and then force her to drop her pants? Or did he cut her pants from her? It says Petty cut plaintiff with the knife on her stomach as he wrestled with her to remove her pants. It didn't say that he removed her pants. He was wrestling with her. He wanted to get her pants off. So they were wrestling and tussling. Then he grabbed her by the sides to cause pain so that she would release her hands from her pants and remove them. Petty forcibly inserted his erect P into plaintiff's V. As a result of Petty's conduct, plaintiff has suffered physical injury, severe emotional distress, humiliation, embarrassment, paranoia, depression, anxiety, economic harm, and other consequential damages. The conduct of Petty described above was willful, wanton, and malicious. At all relevant times, Petty acted with conscious disregard of plaintiff's rights and feelings, acted with the knowledge of or with reckless disregard for the fact that his conduct was sure to cause injury and humiliation to the plaintiff, and intended to cause fear, physical injury, and pain and suffering to the plaintiff. By the proceeding, plaintiff is entitled to recover punitive and exemplary damages from Petty. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, loss of enjoying life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Count 3 against Petty, assault, sexual assault, New York. Plaintiff alleges and incorporates by reference the allegations in the preceding paragraphs. Allegations of sexual intercourse by forcible compulsion, if proven, potentially constitute criminal rape under New York law. A person is guilty of rape in the first degree when he or she engages in sexual intercourse with another person. So, let me explain what we are about to uncover right now. This is showing you that he was originally charged and guilty of rape in the first degree. But when taking the plea deal, it was lowered to attempted rape. This is where we get into that. This is what they are citing: criminal rape under New York law. Person is guilty of rape in the first degree when he or she engages in sexual intercourse with another person by forcible compulsion. In the civil context, the common meanings of assault and battery subsume all forms of tortious, menacing, and unwanted touching. Rape indisputably encompasses civil assault and battery under New York law. Petty in doing the things herein alleged, including intending to subject plaintiff to sexual abuse and harassment by Petty during plaintiff's time as a 16-year-old high school student, Petty intended to cause harmful or offensive contact with plaintiff's person, or intended to put plaintiff in immediate apprehension of such contact. So, it looks like to me that sexual assault is also being alleged as a charge in this case. So because they are trying to get her to recant her statement, thank you, Queen of Harlem. Thank you. Because they are trying to get her to, hey, Cocoa Butter Barbie. Hey, Together We Break Chains. Welcome. Hey, Toxic K is Toxic. So because he did that back then, first degree rape is what he would have been charged with and convicted of had he not taken the plea deal. So when taking the plea deal, they lowered it to attempted rape because that is what would carry the 4-year sentence. So they're also alleging sexual assault because he did sexually assault her back then. And she feels as though because you guys are harassing me and you're trying to get me to recant my statement, I am reliving this shit all over again. I'm reliving this over and over. Petty in doing so in these things alleged, including intending to subject plaintiff to sexual abuse and harassment by Petty doing so during this time, it's put her in imminent apprehension of such contact. In doing the things herein alleged, plaintiff was put in immediate apprehension of Petty's harmful or offensive contact, and Petty made harmful or offensive contact with plaintiff's person. Plaintiff did not consent to Petty's intended harmful or offensive contact with plaintiff's person, or intent to put plaintiff in immediate apprehensive of such contact. Additionally, because plaintiff was a minor during the time herein alleged, she could not consent to sexual contact with any person. In doing the things herein alleged, Petty violated plaintiff rights under Civil Code Section 43 of protection from bodily restraint or harm and personal assault. So, as a result of the above described conduct, the plaintiff suffered and continues to suffer great pain of mind and body, shock, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life, has suffered and continues to suffer, and was prevented and will continue to be prevented from performing daily activities and obtaining the full enjoyment of life. Plaintiff has sustained loss of earnings and earning capacity. In subjecting the minor plaintiff to the wrongful treatment herein described, Petty acted willfully and maliciously with intent to harm both plaintiffs in conscious disregard of both plaintiffs' rights to constitute malice and oppression. Therefore, the plaintiffs are entitled to the recovery of punitive damages in an amount determined by the court against Petty, and as sum to be shown according to proof. Defendants' unlawful actions constitute bad faith, malicious, willful, and wanton violations of the plaintiff's rights, for which the plaintiff is entitled to an award of punitive damages. Count 4 against Petty. Negligent infliction of emotional distress. Plaintiff alleges and incorporates by reference the allegations in the preceding paragraphs. Negligent infliction of emotional distress requires a showing of 1, extreme and outrageous conduct, 2, a causal connection between the conduct and the injury, and 3, severe emotional distress. And then they cite cases where this was found. Here, the actions of Petty rise beyond the threshold of extreme and outrageous. As previously mentioned, Petty viciously raped the plaintiff and admitted doing so within hours of committing the act. In the days, months, and years preceding his criminal act, Petty, his enabling parents, associates, legal team, gang affiliates, agents, and servants worked in concert and engaged in conduct that rise beyond the threshold of extreme and outrageous. The extreme and outrageous conduct are as follows. Stalking the plaintiff. Stalk the plaintiff's 22-year-old daughter. Stalking the plaintiff's family members. Causing plaintiff to move residence on multiple occasions throughout the years, bribing the plaintiff into recanting her rape claim, threatening the plaintiff with physical bodily harm if she did not recant her rape claim, and threatening the plaintiff with death via social media posts. Now, under California law, negligent intentional infliction of emotional distress has the following elements. And they're using California law because that's Nikki and Kenny's jurisdiction. Number 1, a legal duty to use reasonable care. 2, breach of that duty. And 3, proximate or legal cause between the breach. And 4, the plaintiff's injury. Here in 94, Petty accepted a plea deal after savagely raping the plaintiff. As part of that plea deal, Petty was prohibited from directly or indirectly contacting the plaintiff. The purpose of that plea agreement provision is to protect the plaintiff from experiencing a further injury that directly or indirectly may cause contact from Petty. As a result of this agreement, Petty assumed a duty to prevent the plaintiff from experiencing any such harm. On multiple occasions, Petty negligently violated the duty he owed the plaintiff. Petty's actions endangered the plaintiff's safety and caused her to fear for her and her family's safety. So what they are saying here is that because of Kenneth Petty's actions, knowing that he was not supposed to have contact with her directly or indirectly as part of his plea deal, and he was not supposed to put her in danger, he did so by having his friends contact her, by having Nikki contact her indirectly or directly. And he should have known better, because if he was sticking to the plea deal, he wouldn't have been doing these actions. So that's what they mean by that. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Count 5. Now, this count is against Petty and Nicki Minaj. Harassment and witness intimidation, both in California and Georgia. Plaintiff alleges and incorporates by reference the allegations in the preceding paragraphs. Harassment in this code is defined as unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. Under law such and such, the course of conduct must be such as would cause a reasonable person to suffer substantial emotional distress and cause substantial emotional distress to the plaintiff. Regarding Georgia's harassment statute, Petty and Defendant Minaj directed their tortious activities at plaintiff. At the same time, plaintiff was a resident of the state of Georgia. Plaintiff felt the impact of defendant's actions in the state of Georgia. Defendants executed their harassing communication directly and indirectly through their intermediaries. One moment, guys. All right. Okay. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury. Excuse me, guys. Give me 1 second. I had to blow my nose. Sorry. Embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. In March 2020, in violation of his 1994 plea deal, Petty and Defendant Minaj intentionally and repeatedly harassed and contacted plaintiff through their intermediaries. Defendant and Defendant Minaj engaged in courses of conduct which alarmed and seriously annoyed the plaintiff and served no legitimate purpose. Defendants attempted to compel plaintiff not to communicate truthful information regarding Petty's conduct and recant her statement through intermediaries. Defendants created fear of physical injury by finding plaintiff's whereabouts after the plaintiff moved several times. Defendants' associates approached plaintiff's family members in New York, approached plaintiff's 22-year-old daughter in Georgia, and approached the plaintiff herself. In summary, defendants engaged in constant phone calls, resident pop-ups, family member reach-outs, unsolicited contacts, bribing, and attempted coercion. Defendants knew or reasonably should have known that such communication would cause the plaintiff to fear harm to plaintiff's physical safety and property and a member of plaintiff's family. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Count 6. Defendant Minaj. Now, this is against Nikki alone. Aiding and abetting, California and Georgia. Plaintiff alleges and incorporates by reference the allegations in the preceding paragraphs. In California, liability for aiding and abetting the commission of an intentional tort may be imposed upon a person who knows the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other to so act, or gives substantial assistance to the other in accomplishing a tortious result, and the person's conduct separately considered constitutes a breach of duty to the third person. So basically, when you aid and abet in California, when you're legally knowing that you are allowing a person to breach a duty of conduct upon another person, you're giving encouragement in them to do so. You're giving them substantial assistance to accomplish a tortious act. So you are aiding and abetting. You are assisting them in committing a crime and assisting them in harming intentionally or unintentionally a person, a third party. While aiding and abetting may not require a defendant to agree to join the wrongful conduct, it necessarily requires a defendant to reach a conscious decision to participate in a tortious activity to assist another in performing a wrongful act. See, I just said that. When you assist another person in doing wrong. I just explained that. Exactly, Knight Rider. By not making him register as well. That is also aiding and abetting. Absolutely. Similarly, the 11th Circuit held a defendant is liable for aiding and abetting a tortious act if the defendant does a tortious act in concert with the other or under a common design with him, or knows that the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other so to conduct himself, or gives substantial assistance to the other in accomplishing a tortious result, and his conduct, separately considered, constitutes a breach of duty to the third person. Defendant Minaj knew that the plaintiff possessed information relating to a criminal occurrence. Here, her rape by Defendant Minaj's spouse, Petty. Defendant Minaj knew that Petty was required to register as a sex offender in the state of California. Here you go, Knight Rider. Here's your aiding and abetting. Defendant Minaj knew or should have known that Petty's 1994 plea deal prevented him from directly or indirectly communicating with the plaintiff. Despite this, Defendant Minaj engaged in acts of bribery, harassment, stalking, and intimidation by calling the plaintiff and instructing her attorneys, associates, and affiliates to stalk, intimidate, harass, and bribe the plaintiff into recanting her 1994 rape charge against Petty. As previously stated, Defendant Minaj's actions serve no legitimate purpose other than to aid her husband's acts of harassment, stalking, bribery, and witness intimidation. Additionally, Defendant Minaj created fear of personal injury by finding plaintiff's whereabouts after the plaintiff moved and changed her phone number several times. Defendant Minaj's associates approached the plaintiff's family members in New York, approached the plaintiff's 22-year-old daughter in Georgia, and approached the plaintiff herself. In summary, Defendant Minaj engaged in constant phone calls, address pop-ups, family member reach-outs, unsolicited contacts, bribing, and attempted coercion. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Count 7 is against both Minaj and Petty. Intentional infliction of emotional distress, both in California and Georgia. Plaintiff alleges and incorporates by reference the allegations in the preceding paragraphs. In California, to state a cause of action for intentional infliction of emotional distress, a patient must show outrageous conduct by the defendant's intention of causing or reckless disregard of the probability of causing emotional distress, the plaintiff suffering severe or extreme emotional distress, and actual and proximate causation of the emotional distress by the defendant's outrageous conduct. Conduct to be outrageous must be so extreme as to exceed all bounds of that usually tolerated in a civilized society. Then they just go in to break down in Georgia what intentional distress is. In violation of the California and Georgia law, Defendant Minaj and Petty have satisfied the elements of intentional infliction of emotional distress. Defendants were residents of the state of California when they engaged in their tortious and criminal acts. Furthermore, defendants aimed and directed their tortious and criminal acts towards the plaintiff, a resident of the state of Georgia at this time. That's why the jurisdictions are California and Georgia. And that's why they are citing both laws under those states so that they can't try to say what they wanted to say in the beginning and what you're going to see them say in Nicki Minaj's pretrial letter, or, her answer to being late. They're going to say that they don't have jurisdiction because she said that most of this happened to her in New York and Georgia, but the defendants live in California. Well, when they are citing what they're suing for, they are citing that they are suing under California and Georgia law to cover where everyone lives. In summary, defendants Minaj and Petty's intentional conduct included, but was not limited to, bribery of plaintiff by sending their associate Black to the plaintiff residence with $20,000 and offering to have defendant Minaj record a birthday video for the plaintiff's daughter. Bribery of plaintiff by approaching the plaintiff's family members in New York, offering $500,000 in exchange for plaintiff recanting her 1994 rape claim against the defendant. Stalking and harassing plaintiff's 22-year-old daughter while her daughter was out with friends in Georgia. Stalking and harassing plaintiff by calling and showing up at the plaintiff's home after the plaintiff changed her phone number and residence on multiple occasions. Intimidating the plaintiff's family in New York with threats of physical bodily harm if the plaintiff did not recant her 1994 rape claim. These threats resulted in the plaintiff moving out of Georgia to a remote location in the state of Florida. And through their associate Black, they are threatening to kill the plaintiff on social media. Defendants' actions were intentional and the conduct was extreme and outrageous. Undoubtedly, there was a clear causal connection between the conduct and plaintiff's emotional distress. Plaintiff's emotional distress is persistent and severe, so much so the plaintiff has not worked since having to move over 3 times within 12 months, as she has been in fear for her life and safety. As a result of the above described conduct, plaintiff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, loss of enjoying life. Plaintiff has been prevented and will continue to be prevented from performing her daily activities and obtaining the full enjoyment of life. Jury demand. Plaintiff demands a trial by jury as to all issues so triable. Prayer for relief. Now, this is what the plaintiff prays for judgment against all defendants jointly and severely as follows. This means this is what Jen hopes will happen. For past, present, and future general damages in an amount to be determined at trial. For past, present, and future special damages, including but not limited to past, present, and future lost earnings, economic damages, and others in an amount to be determined at trial. Any appropriate statutory damages for costs of suit, for interest as allowed by law, for attorney's fees. The cause of action authorize any appropriate punitive or exemplary damages against defendants Petty and Minaj, for such other and further relief as the court may deem proper. And this was entered on September 2nd, 2021 by Tyrone A. Blackburn. And the rest of the pages are the exhibits that we talked about. So then we go right into Tyrone is attempting to serve Nikki and Kenny. He's attempting to serve them, but has not been able to serve them. He had not been able to serve them. Let me pull up those documents. So in August, on August 31st, Tyrone sends a letter to the judge because the original complaint, remember, it was sent and entered August 13th. Before they, did their amendments or whatever, they originally filed the lawsuit and entered it in August 13th. So on August 31st, Tyrone reaches out to the judge because they are having difficulty serving Nicki Minaj and her husband because they're ducking being served. So Tyrone writes to the judge. I just had to take a little swig of Gatorade, y'all. My mouth is parched. My firm represents plaintiff Jennifer Hough. Ms. Hough in the above referenced matter. Ms. Hough has made several attempts to serve a copy of the summons and complaint on defendant Nicki Minaj and her husband, defendant Kenneth Petty. Defendant's home address is not publicly listed. This writer has reached out to the last known counsel for defendant Nicki Minaj and the current defense counsel for defendant Kenneth Petty. Both counsels have ignored my emails and phone calls. Defendant Nicki Minaj recently settled a civil suit in California, and her counsel of record is Peter Ross of Brown, George, Ross, O'Brien, Ogney, and Ellis, LLP. Defendant Kenneth Petty is currently facing federal criminal charges in the District of California for his failure to register as a sex offender stemming from the vicious rape he visited upon plaintiff Hough in 1994. Defendant Petty is represented by Michael Goldstein of Goldstein Law Group and Hagop Kanyujan of Kanyujan Firm, APZ. We are writing to ask the court for an extension to serve the summons and complaint on defendants Minaj and defendant Petty. We are also asking the court to approve services of process via the U.S. Marshal's office. If the U.S. Marshals are unsuccessful, we intend on petitioning the court for service of process via publication. So he shows where Nikki is represented by her attorney, and they are showing Kenneth's attorneys signing the bottom, being cited in his failure to register as a sex offender. So what Tyrone is saying, I am going through these attorneys trying to get their clients served, and they will not answer my calls. They will not give me their address. They are ducking me. So they were not able to serve them as of August 31st. But I guess as they kept on trying, they finally reached someone at Nicki Minaj's residence. Okay. And I'm going to pull that, but I'm going to blot out her address. So give me a moment. Give me a moment. I am getting both of the summons for Nikki and Kenny. This was entered in court on September 17th, and it was served to their home on September 15th. One for Kenny and one for Nikki. Let me blot out this address because I don't want to dox Nicki Minaj. I don't want anyone knowing Nicki Minaj's address. So let me get rid of that. The attorney's addresses is fine because that's public record. You can look up attorney's information on Google, so that's nothing. But personal addresses, no ma'am. I am not putting that because her address is not listed. So there's no way I'm going to put that out there. I'm blotting it out now with a little pencil. So with a little electronic pencil. So give me a minute, guys. I'm a coming. All right, there we go. Okay. All right. So here is the summons for this summons is for Onika Tanya Mirage. I left the summons at the individual residence or usual place above with Kenneth Petty, aka Zoo, husband, a person of suitable age and discretion who resides there on date 9/15/2021 at 6:25. And I mailed a copy to the individual's last known address, and they didn't say that because they didn't mail a copy. They served it directly to Kenneth Petty. And it says down here, description of Kenneth Petty was a black male, 40 years old, 200 pounds, 5'10", black hair, brown eyes. They also served Kenneth Petty his own document. They also served him his own document. Okay, let me show you that one. Kenneth Petty, aka Zoo. He personally served him his summons as well. Black male, 40 years old, 200 pounds, 5'10", black hair, brown eyes. Okay. So usually, and I know with any other, when you serve someone, they ask you your name. They walk up on your property, they knock at the door, or if you're outside or whatever, or wherever they find you at, they walk up to you. They say, Kenneth Petty? You say yes. They say you've been served, and they hand you the document and they go on about their business. They do not just hand a document to someone without asking who they are. They say, Kenneth Petty? Are you Kenneth Petty? Yes. Here you go. You've been served. They do not just walk up on someone and don't ask a name. That is false. A server walks up to a person. He's seen that it was Kenneth Petty. He already knows what Kenneth Petty looks like because the job of the server, they are given the person's photo. They know what both defendants that they are serving look like. That's why he didn't say Nicki Minaj. He knew that that was her husband. That's why he gave both documents. If he was not sure that was Kenneth Petty, he would have not given him Nicki Minaj's summons as well, because you are able to take your spouse's summons. He would have not given her summons to some random person. You are able to take the summons for your spouse because they are married. So that is why he left the documents with Kenneth Petty, with both of them. He had his photo, he ID'd him, and he said, Kenneth Petty? He said, yeah. He didn't even realize, because when they serve you, it is very off the wall, very unexpected. You are not expecting it. They just walk up on you. You've been served. Boom. And they ask you who you are. So there's no disputing that. That is how that is done. All right. Now, what were they actually served? They were served the lawsuit summons, informing them that a lawsuit had been filed against them. Okay. And this is what the actual lawsuit summons looks like. That paper that I just showed you is basically like a receipt. All right. It's a receipt that he submitted this document to them. He gave them each their summons to appear in court in a civil action. It says, Onika Mirage and Kenneth Petty, a lawsuit has been filed against you. So this was given to them on September 15th at 6:25 p.m. A lawsuit has been filed against you. Within 21 days after service of this summons on you, not counting the day you received it, or 60 days if you are the United States or a United States agency or an officer or employee of the United States, you must serve on the plaintiff an answer to the attached complaint or a motion under Rule 12 of the Federal Rules of Civil Procedure. The answer or motion must be served on the plaintiff or plaintiff's attorney, whose name and address is Tyrone Blackburn, and the address. If you fail to respond in the 21 days, judgment by default will be entered against you for the relief demanded in the complaint. You also must file your answer or motion with the court. So that is what was served to them on the 15th. So the fact that they say that they were not aware of the lawsuit, and that's why they were late, they were served, or someone was served on 9/15. So for the sake of devil's advocate, let's just say that the server did not serve Kenneth Petty. Let's just say, for the sake of both sides, let's see Nikki's point of view. If she is saying, if she's going to say through her attorney that she was not properly served because she was not physically served, Kenny was the one that received the documents. Well, first of all, you are married. That is your spouse. A spouse can receive things for his wife. It is your duty, sir, to let your wife know that she is in a lawsuit, involved in a lawsuit with you. Just like when a husband steps out on his wife and he creates a child out of wedlock and he has to pay child support. If you are married, the child support agency will take money from your wife's check if you do not work. If your wife has a job, I removed that person. We are not putting that out there. I do not care if it's on the registry. Why would you put that in the chat? You do not. The next person, if they ever do anything like that again, you will be blocked. Now you are blocked from my platform. We are not putting any addresses or anybody's names, private stuff in the chat. Please do not do that. Okay, so like I know what her address is. I just blotted it out. You had to just know, you just wanted people to know that you had the address. That's very childish and very immature. Why would you do that? We all know, girl. Okay, girl. Okay, you got your attention. Okay, girl. You subscribe just to do this silly shit. So, very strange. So you're able to pay for your for your husband's children. Like if your husband has a child out of wedlock and he ain't got no job, they're going to dox your check. They will take your money. So the same way that that can occur, why would he not think that you can accept your wife's summons? So yeah, nice try. Nice try. Okay. So now time is going by. Time is going by and nobody is answering to the lawsuit. Nobody's answering to the lawsuit. So on October 11th, they had until October the 6th to answer to the lawsuit, to enter their plea. And October 6th comes and goes, and nothing is heard by defendant Petty or Minaj. So Tyrone Blackburn enters in default, win by default by judgment. Request for certificate of default. He wants to win the lawsuit by default because time has ran out and there is no response by Nicki Minaj. So Tyrone enters this letter into the court. Please enter the default of defendants Onika Tanya Mirage, aka Nicki Minaj, and Kenneth Petty, aka Zoo, pursuant to Rule 55A of the Federal Rules of Civil Procedure for failure to please or otherwise defend this action as fully appears from the court file herein and from the attached affirmation of Tyrone A. Blackburn, Esquire. Basically saying he's outlining the entire case, everything that happened with the rape and the harassment and all of this. And so he's now saying because the defendants feel as though they are above the law, they have not answered to their lawsuit. So he is asking that Ms. Hough is requesting an award of damages of $20 million. So Nicki Minaj's lawyer then reaches out to Tyrone Blackburn on October 14th via email. Okay. Let me get that. All right. Okay, here we go. So the lawyer reaches out to Mr. Blackburn on October 13th. And he says, "Dear Mr. Blackburn, I expect to file a notice of appearance tomorrow on behalf of Nicki Minaj in the above referenced action, albeit without conceding that the court has personal jurisdiction over Ms. Minaj. I am aware that you filed a request for a certificate of default on October 11, 2021. I am writing to ask you that you voluntarily withdraw your request and agree to an extension of time until November the 1st to answer or move against the complaint. Otherwise, we will both waste our time litigating a motion on which Ms. Minaj will surely prevail to set aside the default. Please let me know whether you will agree to my request at your earliest convenience." And then he says, "P.S. My apologies in advance for any typographical and grammatical errors. I'm a terrible typist and proofreader, particularly when I'm drafting an email under time pressure." So Tyrone writes back, "You can file your opposition and explain to the court why your client believes that her and her husband are above the law. I do not consent to an extension." So a couple people have been pointing out that Nicki Minaj is represented by an attorney and not her husband. However, Nicki Minaj and Kenneth Petty are married, okay? Nicki Minaj is strategically separating herself from Kenny in an attempt to say that she was not served, she was not properly handed a summons, she is separate from Kenny. This is an attempt to do that. Now, I am not certain if because they are married, would that make a difference? Do they both have to have lawyers, separate lawyers? Do they both have to have legal counsel specifically stating that they are representing Kenny and this one is representing Mirage? So we have to keep remembering that they are married. They are married. That is a huge difference between someone that's single and someone that's married. So we will wait to see how that plays out. We'll wait to see if that is something that will make a difference. Will that separate Nicki Minaj from this lawsuit? Because she is distinguishing that she is represented by Judd Bernstein. It does not say Hough versus Mirage and Petty. It says Hough versus Mirage. So we will have to see how that plays out. We cannot make any guesses. We cannot make any determinations because we do not know. We are not the judge. We are not the lawyers. We can only speculate. We have no proof that Kenny does not have a lawyer. It just has not been entered. There are no documents specifically addressing Kenneth Petty yet. We are still in the preliminary phase of the case where we are submitting motions. We're not at discovery. We are in the pretrial phase. So we don't know if it's going to come about that Kenneth Petty is represented by an attorney. We have to wait and see. Every day there are updates to this case. Every day. So Nicki's lawyer finally responds to the court for Nicki Minaj on October 14th. And they entered it into the docket on the 15th. So please take notice that upon the attached declaration of Defendant Onika Tanya Miraz, executed on October 14th, the annexed declaration of Judge Bernstein, executed on October 15th, and the exhibits annexed thereto, the accompanying memorandum of law, and all prior proceedings heretofore had herein the undersigned on behalf of Defendant Nicki Minaj. This is a pretrial letter as required by the court's individual practices. Judge Bernstein declares under penalty of perjury, I am an attorney admitted to the bar of this court. My firm represents Onika Tanya Miraz. I submitted this declaration in support of defendant's motion seeking leave to file a late letter requesting a pre-motion conference in anticipation of a motion to dismiss the amended pursuant to federal RCIVP 12. And then they have different the exhibits. The exhibit A is a copy of the pre-motion conference letter. And exhibit B is a copy of his email to Tyrone Blackburn. And exhibit C is an article posted in the Daily Beast where he is trying to show that Tyrone is media hungry and just wants media attention. Now, a pretrial conference is a conference to bring the prosecutor and the defense attorney together to explore possibilities of resolving the case without going to trial. So Nicki Minaj's attorney is requesting a pre-trial conference. They want to explore possibilities of resolving the case without going to trial. Okay? So this is not just a letter asking and excusing that we be late. Please don't find in favor of Jennifer in default and make us pay $20 million. We also would like a pretrial conference with you and the defendant and the plaintiff because we want to try to settle out of court. Now, who would want to try to settle out of court if they are not guilty? That's just an observation. So, the amended complaint should be dismissed pursuant to rule whatever. He's saying that it should be dismissed because the defendant said she felt the bulk of her actions in Georgia and New York. She's saying that it says in the first instance, plaintiff has not met her burden because the amended complaint does not allege any basis for venue in this district. Instead, stating only that the plaintiff felt the bulk of defendant's actions in the states of Georgia and New York. This allegation does not support the venue because the venue requires that the events took place in the relevant district. Well, that's not true because as we read those documents, they are suing for California and Georgia. So even though she said the defendants, it took action in Georgia and New York, she is suing in Georgia, New York, and California because the lawsuit specifically addresses each state that situations took place. So you got to be very careful. This lawyer is making mistakes because in the briefing, we just read it. They very much so did reference all three states. Give me 1 second, you guys. I'm gonna take my allergy medicine real quick. Give me a moment. All right. So now I note my belief that there appear to be compelling reasons to dismiss the amended complaint under Rule 12b-2. Pursuant to my Rule 11 obligations, though, I am not pressing this argument now, as I need to undertake some additional investigation of the facts and law. However, defendant does not intend to waive a claim that the court lacks personal jurisdiction over her by reason of not discussing it in this letter. Turning then to the alleged events in the case, plaintiff is undoubtedly resting her venue claim upon the fact that the attempted rape for which defendant's husband was convicted occurred in Queens County. However, the location of that event is irrelevant to the issue of whether venue as to the defendant is proper, because when venue is challenged by a defendant, plaintiff bears the burden of proving that venue is proper in the forum state. Given the page limit for this letter, I cannot detail each of the amended complaint's minimal allegations against defendant, but they may be found at paragraphs 82, 84 to 85, 88 to 94, and 100 to 104 thereof. Not a single one of these allegations even remotely suggests conduct in New York. The lack of any connection between these allegations and the Eastern District of New York is further demonstrated by the fact that the three claims for relief asserted against defendant in the amended complaint, counts 4, 5, 6, and 7, all seek relief only under California and Georgia law. If plaintiff were alleging that defendant engaged in any conduct in New York, she would have also sought relief under New York law. So what she alleged in New York was the rape. And when she alleged those claims, those were directed towards Kenny. What she directed at Nikki for the harassment, if he was following along. Now, where was he when I was reading these documents? Because, honey, you would have known that Tyrone is filing for relief in California and Georgia as it pertains to the harassment. And that's when Nikki comes into play. So when New York is being cited, the lawyer refers to Kenny and the rape. Nikki is not in those paragraphs. When we broke down the counts, did you notice each count that was supposed to go with whoever, they had the state that it was going to be under and who it was going to be for. So this is not true. This statement he made is false. that's not accurate. And we just been on here for almost 2.5 hours and we read that. The complaint should be dismissed pursuant to Rule 12b-5. Once a defendant moves to dismiss under Rule 12b-5, the plaintiff bears the burden of proving adequate service. Here, defendant has made an evidentiary showing that she was not properly served. The affidavit of service filed by plaintiff, docket number 14, states that the defendant was served via personal service of a copy of the summons and complaint upon her husband, who is described as a black male, 40 years old, 200 pounds, black hair, brown eyes. Defendant, however, has executed a sworn declaration in which she states that the process server is not telling the truth, as this never happened. In fact, my husband is approximately 5'9" and weighs no more than 175 pounds. Further, there is no person who resides in our house or who was present there on September 15th who fits the description contained in the affidavit of service. So Nikki is attesting that the process server is lying and that he never served Kenny or anyone, that he did not give it to anyone. And if he did, it couldn't have been a man that was 200 pounds, black hair and brown eyes, because the person doesn't even live there and it wasn't no one there that day that fits that description. That's a bold-faced lie. Process servers, they have guidelines that they have to follow. Process servers, it is very serious. That is a very serious job. And I would not, if they're able to prove this, that process server needs to be fired. He needs to be fired, and his job needs to be investigated, and he needs to be brought up on charges. Because if he lied and said that he served Kenneth Petty and he did not, then he needs to go to jail. He needs to, his credentials need to be removed, and he need to go to jail. If he broke the rules of a process server, he didn't have a picture and didn't know what Kenny looked like, he didn't ask Kenneth Petty and then serve him, if he just walked up to that house, walked up to a random person and gave them that summons, he needs to be fired. Period. And if that is the case, Nicki Minaj absolutely was not properly served because she herself was not served. Now, if Kenneth Petty was served, if they're able to prove that Kenny was the one that took those documents, he absolutely can accept it on his wife's behalf. So when you get these high-priced lawyers, usually that's what they do in the preliminary stages. They try to find loopholes to get the case thrown out. That's what they try to do. So count 5 alleges. C. The complaint should be dismissed pursuant to Rule 12b-6. The 3 claims for relief asserted against the defendant are most intelligible and certainly not sufficient to withstand a motion for dismissal. The Queen Radio reference in paragraph 84 of the amended complaint refers to the name of an Apple Music show, not Queens, New York. Now, when he said that in this sentence, I didn't know where he was trying to go with that, because we all know that Queen Radio means her Queen Radio show. No one thought that it was referencing Queens, New York. So I don't know where he was going with that. The Queen Radio referred in paragraph 84 of the amended complaint refers to the name of an Apple Music show, not Queens, New York. Okay, what does that mean, sir? We know. I didn't understand what that meant. And in that case, when we enter into discovery, Auntie Nisi says the process server takes a picture of whoever he gave the paperwork to. Well, if that's the case, then we will see that during the discovery phase. We will be able to learn if that's a lie or not. Alice says, could they have bought a process server off? That's against the law. It is against the law, but anything can happen. You never know what type of bribes people take. Look what that person did with Tasha K. Gave R. Kelly's documents, and she was a prison worker. She wasn't supposed to be giving prison documents to people, but she was. So you never know what people would do. But we will learn as time goes on. We will start to have evidence entered as we get into the discovery phase and as they fill out the interrogatories and each side asks for things, if we make it that far. They are asking for a pre-trial conference, and a pre-trial conference is to settle without going to trial. So if they go to a pre-trial conference, it just might be settled without going to trial. Alternatively, pursuant 28 USC 1406, this case should be transferred to the Central District of California, which is the district in which both defendants reside. Count 5 alleges that the defendant engaged in harassment and witness intimidation under California and Georgia law. The claim under California law is facially frivolous because plaintiff is seeking damages for a violation of California Civil Process 527.6. That statute, however, provides only for injunctive relief. Because the statute does not provide for an award of damages, that should be dismissed. As for plaintiff's reliance upon a supposed Georgia's harassment statute, there does not appear to be one that gives rise to a civil remedy for damages. Liability may only be authorized under a penal statute when the General Assembly has expressly provided for a private right of action in the textual provisions of that statute, not extrapolated from the public policy the statute generally appears to advance. As drafted then, the amended complaint failed to state a claim for harassment and witness intimidation because it does not even identify a claim pursuant to which a plaintiff can seek damages. That being said, it is hard to imagine that the meager allegations against defendant in the amended complaint would provide factual content that allows the court to draw the reasonable inference that the defendant is liable for some tort under Georgia or California law. But how can one assess the adequacy of factual allegations if the plaintiff has not identified a claim for which those factual allegations are supposedly adequate? To me, this lawyer is like full of mumbo jumbo. He likes to use large sentences and large words. I don't understand a damn thing he is saying. It makes no sense. And it doesn't have, this is not some fancy, smancy, oh, he's a high-priced lawyer, so that's why you don't understand it. No, he's full of shit, and he's trying to find loopholes. And usually that is what lawyers that are high-priced, that's what they try to do. They try to do less work possible. They want to make money quick. So they try to do less work possible. So they want to try to get you off with a legality and a technicality. And that's what this screams I'm trying to get them off. So count 6 of the amended complaint alleges that the defendant is liable for aiding and abetting under California and Georgia law. This claim is incomprehensible because a claim that a defendant was aiding and abetting another person is meaningless unless the plaintiff also identifies the underlying conduct which was supposedly being aided and abetting. And they did say what was being aided and abetting, that you didn't allow him to register as a sex offender. You encouraged him not to do that. So you were aiding and abetting. Here, the amended complaint fails to do so. No, they did. So see, this, I just can't even rock with this. I can't read it. It's a bunch of bullshit. I'm going to read count 7 of the amended complaint alleges that the defendant should be held liable under California and Georgia law for intentional infliction of emotional distress. The allegations against defendant in the amended complaint do not remotely make out the allegations of that tort under either California or Georgia law. That all of the claims made under the defendant are brought under California law and Georgia law raises issues concerning whether a defendant can be held liable for acts committed outside of a state simply because a plaintiff felt the effect of the acts there. Plaintiff appears to be contending that as a victim of a tort committed against her in a state, she can sue the wrongdoer under the law of state B 10 years later because she has continued to suffer from the effects of the tort after moving there. This makes no sense. That is not what is being alleged. What is being alleged is that they were harassing and threatening her and she had to move. They were offering her money. I don't understand this lawyer's train of thought, and he better get on board quickly. This looks like something quick to put together because they were late. This looks like they were just trying to put something together really quickly, and he didn't do his homework. He didn't read the briefings. He didn't read the complaint. Because his response, it's very vague and it's not accurate. Even I am picking out inconsistencies in this response. So I would really urge him to read the briefing before he goes any further. So basically, this is the declaration of Onika Mirage, and it's saying why she was late. Okay. So Onika Mirage declares under penalty of perjury pursuant to 28 USC 1746 that the following is true and correct. I am a defendant in this case. I am advised that plaintiff has filed an affidavit of service from a process server who claims that my husband and I were served because he personally handed the summons and complaint to my husband, who he describes as a black male, 40 years old, 200 pounds, black hair, brown eyes. The process server is not telling the truth, as it never happened. In fact, my husband is approximately 5'9" and weighs no more than 175 pounds. Further, there is no person who resides in our house or who was present there on September 15th, 2021, who fits the description contained in the affidavit of service. My failure to respond to the complaint by the date which plaintiff claims was my last date to do so was the product of series of innocent miscommunications. After learning about the complaint, I sought out recommendations for a lawyer in New York. On September 22nd, 2021, Mr. Bernstein was recommended to me, and we met on a Zoom conference the next evening. At the end of that conference, now, she says after learning about the complaint, she sought out recommendations for a lawyer, and on September 22nd, Mr. Bernstein was recommended to me, and we met on a Zoom conference the next evening. At the end of that conference, I believe that I had agreed to Mr. Bernstein representing me, and I told him to work out the financial details with my manager, Angela Kowalski. From that point on, I believed that Mr. Bernstein was my lawyer and that I would hear from him when he needed to speak with me. I note that I have not ever had extensive experience with court cases, and I did not know that I was at risk of default while waiting to hear from Mr. Bernstein. I did not learn until October the 12th, when I received papers concerning a default that Miss Kowalski had not understood that I approved Mr. Bernstein as my lawyer, and therefore he had not been retained. Now, let's break down this in a moment. Mr. Bernstein was not available to speak with me until the evening of October 12th, at which time the misunderstanding was cleared up and Mr. Bernstein agreed to represent me upon approval of a retainer agreement and the payment of his advance retainer. So October 12th is after the October 6th deadline. So she's saying she didn't know that she was in danger of default on September 22nd because she just got recommendation about him. She talked to him about representing her on Zoom later that evening, and she told him, go talk to my manager and get the money from her. My failure to respond to the complaint was the product of an innocent mistake, and I asked the court to excuse the delay so that I can defend what I believe to be an entirely frivolous case which plaintiff's counsel has sought against me in an effort to use my name to generate publicity for himself. I declare under penalty of perjury that the foregoing is true and correct. Executed on October 14th. Now let's break this down, okay? So she says that on September 22nd, after learning about the complaint against her, the complaint, I thought you were not served. So where did you get the complaint from? If you were not served and you didn't know anything about this lawsuit because you were not served, remember, the process server took the complaint to her home on September 15th and served it to Kenny. Served it to a man that he believed to be Kenneth Petty. He gave Nikki's and his, right? So she says on September 22nd, after learning about the complaint, I sought out recommendations for a lawyer. How did you know about the complaint if you didn't have the complaint? If you weren't served the complaint, how did you know about it? That's a lie. She's lying, and it's right there. How do you not know about the complaint? You just said on September 22nd, after learning about the complaint, I sought out recommendations for a lawyer. And on September 22nd, Mr. Bernstein was recommended to me, and we met on a Zoom conference call that next evening. At the end of that conference, I believed I had agreed to Mr. Bernstein representing me, and I told him to work out the financial details with my manager. Okay. So how are you saying you were not properly served when you just said you learned about the complaint? And once you learned about the complaint, You sought out recommendations for a lawyer. Paragraph 4A, after learning about the complaint, I sought out recommendations for a lawyer. On September 22nd, Mr. Bernstein was recommended. So that means you got that paperwork on the 15th, and then you start, who can I get as an attorney? And on the 22nd, you settled on him, and y'all talked behind the scenes. Y'all went over the complaint, because what would you be conferencing about? What paperwork would you be talking to him about? What would you be telling him that you need him to represent you for if you had no complaint in front of you? The lawyer had the complaint, she had the complaint, and they went over it. And she did not enter a plea, and he was waiting on her to enter a plea, and she didn't. They got caught up, and they thought that it wasn't going to be this serious. I don't know what lawyer would have let her go in default, would have not said, Nikki, we got to enter a plea. We have to enter something. I do not understand what attorney, what high-priced attorney would let her go in default. It's all right there in black and white, period. So that is his excuse that it was a miscommunication, right? So now, today, we have where Jen has added another attorney. Another attorney has entered into this lawsuit. Another attorney is representing Jen. This does not mean that Tyrone Blackburn is being replaced, because there is no notice of a withdrawal. Now, when an attorney wants to withdraw from the case, he has to enter in paperwork that he wants to withdraw from the case. He has to ask the judge, can he withdraw? So there is no paperwork that shows that Tyrone is withdrawing. All it shows is that there is an attorney that has been added. All right, and here it is. Okay. Appearance of counsel. The clerk of court and all parties of record, I am admitted or otherwise authorized to practice in this court, and I appear in this case as counsel for Jennifer Hough. And his name is Stephen N. Gordon, and he is from Tazengaz and Associates PC. Okay. Now, we saw the lawyer for Nicki Minaj, and it was not Stephen N. Gordon. It was not of Tazenal and Associates. So there you have it. It is not Kenneth Petty's lawyer. It is not Nicki Minaj's associates, lawyers associate. It is an entirely different law firm. Now, if they are acquaintances of those lawyers, that doesn't mean anything. That is not conflict of interest or anything. Law firms and lawyers, they all know each other. The DAs, the judges, all of them, they go sit at lunch and have drinks. They go during recess and during after court and go to bars and clubs. They all know each other. Lawyers, especially in New York, all those high-priced attorneys, prosecutors, DAs, they all sit in those bars and restaurants and make deals with each other. So it's not a conflict of interest. It probably would be in Jen's best interest to get additional attorneys to help Tyrone. Okay? Because he could use some help. And usually with a high profile case like this, you need a team of lawyers, not just one. You need a paralegal, someone to do the research, someone to type up the briefs. You need a team of people. So this is interesting. This is the latest update in this case. Jennifer has added another attorney. And it is not in replacement of Tyrone Blackburn. It is in addition, at this point in time. If Tyrone is going to be replaced, we will see a certificate of withdrawal. We'll see where there will be a letter entered and it will be Tyrone requesting to be withdrawn from the case, to be removed as counsel. That is not entered yet, so that is not happening as of today. As of 10:18, 10:19, 12:45 a.m., Tyrone Blackburn is still representing Jennifer Hough. There is another attorney that has just been added as counsel. All right? So that's where we're at, folks. That's where we're at. We are in the heat of battle. We are in the preliminary stages. We are in, just the whole entering in, information, and we will then move into the discovery phase. And once we move into the discovery phase, we then move into the conclusion, which will be the trial. And if they don't settle out of court when they go to that pretrial conference, if the judge does not grant by default. Now, usually judgment by default is not usually granted. I don't think that that's going to happen. I don't think that Jen is going to win by default. I don't think that she's going to get the $20 million and go on about her business. No, I believe the judge is going to allow the extension. I believe that he's going to entertain the pretrial conference and encourage them to settle out of court. And if they can't reach a settlement, then they will go into the discovery phase. And then that's when we'll start seeing evidence and we'll be able to look at what's being submitted as evidence, answers to their interrogatories on both sides. And we'll get to see what Jen has as evidence to show how she was being harassed. So that's when we'll see all of that. So in my opinion, it's too early to tell what's really going to happen. We are nowhere near this case being over. We are just getting started. These type of cases takes years, sometimes 2 years, a year and a half. We see what's going on with Cardi B and Tasha K. We are going into 2.5 years, 3 years. These lawsuits take a long time, especially with someone like a Nicki Minaj that is a public celebrity that travels, that's, international with it, that has a lot of obligations. It's going to take a long time. They're going to be, extending things as long as they can. They're going to be pushing things out as long as they can. So it's going to take a while. But yeah, we broke it down. We're inside the lawsuit. I'm going to put the link out there. If anyone has any questions and they want to come up, they may do so. I'm going to ask that you show your face and show yourself backstage first before I let you up. If you have questions that you would like answered, you can also drop them in the chat and you don't have to come up. But if you would like to come up and you want to say something, you are allowed to do that now. We're going to do that for 30 minutes and that's it. We're going to end the live. So there's the link. If anyone wants to come up, click the link, please. Show yourself backstage. I need to see your face. You don't have to use your face on the recording, but I need to be able to see that you are a real person and that you're not a troll. Now, if you have a question, you can enter in the chat and I will try to answer them to the best of my ability. Okay, so my thoughts on this and where I am with this. There are a couple mistakes that I see being made so far by both sides. I believe that Tyrone is playing too much in the press. I think he needs to back down. I think he needs to quiet down as far as the press is concerned. I think he needs to stop doing interviews and articles with publications. I think he needs to stop being so visual. You never want to let your right hand know what your left hand doing, or let your left hand know what your right hand is doing. I think it was a smart move to add another attorney. I think that was a great addition. That will be someone to help him where in areas where he may be weak, because he's going up against Nicki Minaj. Let's not front. I'm pretty sure her lawyers are going to be high profile lawyers that are experienced in law and the legal system, that are looking for loopholes. We already see that her lawyer is looking for loopholes. He is looking to put together a defense strategy which separates Nicki Minaj from Kenneth Petty. He is attempting to make Nicki look like she is separate from this, that this is Kenny doing these things. This is not Nicki Minaj doing these things, which is why they strategically did not have the attorney represent the both of them. An attorney for Kenny is going to be his own attorney. But what Nicki is going to do, she's going to clean it up for Kenny. She's going to go take the case. She's basically taking the charges. I'm going to take the charges for my man. I'm going to go in here and I'm going to settle out of court with her and pay her some money to leave us alone. That's basically what it seems like to me. That's what it looked like to me. That I'm going to go in here. I'll get representation by the lawyer. I'm asking for a pretrial conference. I'm going to settle out of court with these issues with her. And then we'll see where it goes with you. But she's suing the both of you. She's not just suing you. She's suing Kenny as well. So y'all got to get a lawyer for Kenny, or y'all got to show what you intend to do with Kenny. Because she's not just suing Nicki Minaj. She's suing the both of them. So the fact that we don't know who his lawyer is or what the defense is for Kenneth Petty, that doesn't mean that he's off the hook. He's part of that lawsuit. So I'm expecting to see some type of documentation entered soon. Who's his lawyer? Who's his counsel? We have two defendants on this complaint. We don't just have one. So she's late. She didn't answer to the summons until late. Kenny has not answered at all. So they can find judgment of default on, in Kenny's situation, but he has no money. What can he give her? What can he give her? That might be the strategy as well. Kenny doesn't have any money. Nicki has money. Kenny doesn't have any money. What can I get from Kenny? What can she get from Kenny when Kenny doesn't have any money? So there's a lot of little different strategies. And I'm really actually glad that nobody wants to come up, because I'm tired. I am tired. We have been at this for 3 hours and 30 minutes. So I really appreciated that you guys was like, no, Sweet Pea, go ahead, girl. You did a good job. We are still here, but we don't need, you basically answer everything. So I appreciate that. That tells me that I did my job. That tells me that I did my job. No problem. We're going to, we went inside the lawsuit, so we will not be doing any more of these until there is another update, and we will just do the update, break it apart, and that's it. We will not be going in depth anymore about the previous documents, because we have covered it thoroughly tonight. We know who's being sued, why they're being sued, where they're being sued, what they're being sued for, how much, and where we currently are. So we're all caught up to speed. We are all caught up. The narrative that I wanted to also address really briefly. I wanted to speak to Kenneth Petty and Nicki Minaj. This is not a hate train. This is not a campaign to smear Nicki Minaj's name. This is a story that is public. They're in a lawsuit. Nicki Minaj is a high-profile celebrity. I am covering it on my channel as content. I do not have anything against Nicki Minaj. Personally, I do not know this woman. I have nothing against her husband. I do not know that man. However, their actions together are dangerous. Someone needs to do something about it before someone is seriously hurt. There has been one woman hurt already as it relates to the Pettys. We do not need another one hurt in that way as well. These two are dangerous together. They are goons. They assert themselves to be goons. They perpetuate an image of violence. Nicki Minaj says she has a violent little boy living inside of her named Roman that wants to harm people, that wants to do harm to others. We have conjured him up and he's never going to leave. He wants to do violence and he wants to hurt people. So she has teamed up with Kenneth Petty and given Roman a playmate. She's given Roman a big brother, someone that Roman can look up to. She's given Roman a father. And together, they're going to wreak havoc if someone doesn't stop them. We do not want to hear the narrative that Nicki Minaj is a sweet woman and that Nicki Minaj is, Nicki Minaj prides herself in being a goon. She prides herself in being a woman that will send niggas to your home. Quote of Tasha K. Nicki Minaj ain't got time to be sitting around. Nicki Minaj ain't got time to be sitting around worrying about no lawsuit or worrying about trying to find evidence or proof for no lawsuit. She will send niggas to your house. Words of Tasha K. Nicki Minaj has prided herself in being in charge of goons. She's always got men behind her. She's always being seen with gang members. So something needs to be done about this, and it needs to send a message that you cannot, just because you're a celebrity and you're married to a celebrity, you're not above the law. You were required to register as a sex offender. That's what you should have done. You should have not sought out Jen, her family, harassed her in order to get your name off of the sex offender registry. You have been registering as a sex offender since you got out of prison. Why all of a sudden did we need you not registering once you got married to Nicki Minaj? If you are truly reformed and you've changed, if that's the narrative, people say he's changed, he did his time, people can change. Well, then take responsibility for who you are and what you are to society, which is a sex offender, and register on the registry and live your life with your husband, your wife, and your son. You do not get to dictate how you're going to run your life as it pertains to the sex offender registry. You don't get to dictate that. That's something. Now, if the court were to have said you qualified for a reconsideration and, somehow your name came up or your time was up and you were to go before the board to reevaluate your case, and then they said you don't got to register no more, that's great. That would have been awesome. That would have been great. However, that's not the case. You took it upon yourself to not register. So if you are reformed and you are a product to society, go register and do what you're supposed to do. This was the conditions of your plea deal. You took a plea in 94 for attempted rape, only because they downgraded the rape charge so that you can get that plea and only do 4 years. Where was Kenny's parents? Kenny seems to have come from a broken home. We had CY on the channel where Kenny was raised in a broken home. Kenny ran the streets. Kenny got in trouble. Kenny had a very bad upbringing and a very bad life. He didn't like being home. He didn't like where he was and who he was. So now that he is married to Nicki Minaj, you think he wants to go back to the streets? And you think Nicki Minaj wants to lose her goon? This is a match made in hell. The two of them deserve each other, and they will not be parted unless they absolutely are made to. Something detrimental is going to have to occur for Nicki to wake up. And it's sad to say it, but that's the only way she's going to separate from Kenneth Petty, because right now she likes this lifestyle. She's enjoying it. And I don't know about you, but if anyone has not noticed the drastic decline in her career since she has aligned herself with Kenneth Petty, you blind. Ever since she has aligned herself with Kenneth Petty, her career has went down the drain. Her numbers are horrible. Her record sales are horrible. Her streaming is down. Her numbers are horrible. Public perception of Nicki Minaj has drastically changed. People do not like her with Kenny. It is not a good look. Even the Barbs are a little frustrated with her. They want music. They want more than just seeing her online with Tay. They want more. They want videos. They want albums. They want tours. They want concerts. They want hit records. But still, and yet, she is consumed with Kenneth Petty. This is why I'm just very sad and just very disappointed for Nicki Minaj, because she was the queen of rap. She was running things for a very long time. A lot of people looked up to her. Her fans prided her. They had a lot of pride, and they took pride in representing Nicki Minaj. And look how she's disappointing her fans. It's disappointing, and it's sad to see, to watch a young Black woman as successful as her. She could have anything and anyone in the world choose a man like Kenneth Petty. It just speaks to her character and what type of woman she really is, what she really thinks about herself. You must have to have some really low self-esteem to think that you can't do any better to reach back in your past and grab your abuser. Oh, you already know what's going on with the sniffles. You already know what it's giving with the sniffles. The rapid weight loss. She's lost a lot of weight. She's lost a lot of weight, and she just does not look like herself. Yep. Chain. Chain of fools. Who, you told me, leave me. Who, my doctor said, come on home. Who, my doctor said, take it easy. But your loving is much too strong. I'm added to your chain. My voice is hoarse, girl. Miss Mary, I know that song, girl. You told me to leave you alone. My doctor said, come on home. My daddy said, come on home. My doctor said, take it easy. But your loving is much too strong. I'm added to your chain. Yes, girl. Who? I know Aretha Franklin, girl. That's my song. And what about If you wanna do right on a woman, you gotta be a do right all night, man. You gotta let Aretha Franklin sing to her, honey. That's them old songs, child. Child, my throat is, child, Jack the voice. I do not have a voice right now. My voice, right. I know that one too, but I why do fools fall? I know that one too, but I'm stuck on Aretha Franklin right now, child. Who you tell me leave you alone? Ooh, ooh, my doctor say, come on home. Ooh, ooh. Take it easy, but your loving is much too strong. I'm added to your chain. Oh, okay. Who are you? You wanna hit your camera?
Oh, I was using my phone.
Hi.
Hi. Oh, so I wanted to say, I think they deliberately answered the lawsuit late because I realized they hadn't responded. So they need to respond to the lawsuits, but by responding late, it's like a deflection. So they haven't answered and they can get it thrown out to prevent her from answering. I was just thinking that.
That sounds like a good. That's like a good strategy. You know what I'm saying? That would be like a strategy to get it to try to find a loophole.
Yeah, because if she said she's not served, then technically she doesn't really need to answer. And we don't know if she was served
True.
or
Yes. Absolutely. But see, that's what you pay those high price lawyers for. They come with tactics like that.
yeah. And I saw where the new lawyer that Jen hired worked with Nikki's current lawyer, so he might know the tactics that her lawyer would pull.
So that's what I tried to do. I looked at the lawyer that she hired and I searched that name with Nikki's lawyer and I didn't find any connection. So you're saying that they work together?
Well, I didn't see it. I just heard somebody else said it, that they worked together for 2 months, or it was a short period of time.
Well, that would be a good tactic because then they would know, what type of lawyer that she got.
Yeah.
And what his experience is. So that's a good tactic on behalf of Jen and Tyrone Blackburn.
So let me see if he's on the website. What's the name of Jen's lawyer again?
So the new one was let me get it for you. So the new one's name is Stephen Gordon, but he works at Tisengall and Associates, and that is spelled T as in Tom, S as in Sam, Y, N as in Nancy, G as in girl, AUZ. Tisengall and Associates, and his name is Stephen Gordon.
Okay, so I saw that, but I don't know if it's the same person. If you look on Judd Bernstein page, you see a Stephen N. Gordon under contact information. We don't know if it's the same Stephen Gordon because the other Stephen Gordon.
So this one does say Stephen N. Gordon. What's the phone number?
Oh, it doesn't link a direct number to the
Okay, because
The
there's a
different
phone number.
contacts.
There's a phone number here too, but when I looked, it was 2 different addresses. So he must
If you
worked.
go on his link and you see it, so go on Stephen Gordon page. He just told me the place that he works, and you'll see that he was an associate at Judge Bernstein from this year, from May to August. So he just left in August when the lawsuit came about.
So that's a great tactic on behalf of Tyrone to go after and get an associate that worked with them. That's great. And that is not conflict of interest because he does not work there.
But then why is this information still up there as a contact?
If he doesn't work there, that's his LinkedIn, right?
Yeah.
So that's like a resume. That's like saying where he used to work.
So they need to update that.
Right.
Probably update there.
Yeah, they need to update it. Mm-hmm. Because, they definitely, lawyers and attorneys, they would know that, oh, we can't hire, like he can't work with us if he still works there. Like Tyrone wouldn't be stupid to do that. They're not going to do anything like that. So if it was a conflict now, if it is a conflict of interest, the judge will damn sure let them know.
Yeah.
Yep, the judge will let them know. So that's what I was saying to people, that once if she's replacing Tyrone, then you'll see a letter of like a notice to withdraw. Tyrone will be asking, can he withdraw from the case?
But if he withdraw, does it mean that the lawsuit stands in effect and she don't need to do anything?
Yeah, the lawsuit stands. Okay. It's just that she's switching attorneys. But right now, all we see is a notice of counsel from the new attorney. So it seems like he's being added. Yep. So it's not a replacement, because if it was a replacement, there would be a withdrawal. Because you in order to, and I know a lot of people know that, in order to get off of a case, when you want to fire your lawyer, the lawyer has to ask the judge, can he be removed from the case? You can't just fire your lawyer. So,
but don't you think it's weird just as soon as they made just as soon as the respondent updated the lawyer, do you think that there was like maybe Tyrone wasn't strong enough or something?
No, I don't believe if Tyrone is being replaced, we will see a letter this week. You'll see it on Pacer. So I'm waiting for it to come out. I'm watching Pacer every hour, checking for updates. If we don't see that, then Tyrone is still on the case. You can't just replace a lawyer without a withdrawal. You have to withdraw from the case. And I looked that up and researched that before I did the show, because I wanted to, check to see, was she replacing him or was he being added? And right now it just looks like he's being added, because the research I did shows that you need to, the current lawyer has to withdraw first, and he has to ask the court. It's called a letter of withdrawal or something like that. Certificate of withdrawal. Yeah. All right. So thank you for coming up. I'm getting ready to go. Thank you so much. I appreciate your commentary and your comments. Thank you for joining us tonight. Thank you. Bye. All right, guys. That's it for me. You guys, this has been another edition of the Sweet Pea Diaries. This was an awesome show. I love you guys. You guys have a great night. Sleep tight. Don't let the bed bugs bite. Be sure to like, share, and subscribe. I holla.
Check the mic and Check the mic, make sure it sound